Okay, let's come to order. Commonwealth versus Dallas Hayes.
Just take it out.
Commonwealth versus Dallas Hayes, 21 CR 00145. We're here for sentencing. You have to say, Mr. Judge.
Your Honor, Commonwealth brief.
Mr. Garner, do you have anything to report to us?
I can't, Your Honor.
Y'all will move to the left here a little bit.
I'm not aware if you read my email in regards to the PSI packet, Your Honor.
Go ahead and put it on the record. You raise your right hand, you swear testimony about to give us the truth, the whole truth, nothing but the truth.
Yes, sir.
Go ahead.
So during the process on February 11th, I believe it was, I went to retrieve the pre-sentence investigation packet as court ordered. And when I went to retrieve it, Mr. Hayes said that he'd thrown it away. And then when I told him the importance of how he needs to do that, to give his opportunity to let you know his side of the story per the 1 page of the pre-sentence investigation, he replied, F you to Judge Williams.
Okay.
And he said it 3 different times. I gave him a second opportunity to do it. We were in agreement that he was going to complete it. And then he turned around and repeated the same statements.
Okay. You have anything to say?
Your Honor, I've spoken to Mr. Hayes and he would like to say something to the court, if the court would allow him to.
Yeah.
Your Honor, I did say to those things under how humbly come to you today is honesty. I was under the influence. I was coming off, detoxing off the drugs. I'm asking for help, man. I'm asking the court for help to help me, send me back out. I can do this time, go back out on the street, do the same thing and continue. Or I'm asking you to help me. I didn't mean directly to you, but besides I was coming up detoxing. I'm asking you to really help me.
Well,
I'll take you kind of.
okay. Well, I appreciate the apology. The problem that I have is these officers, like Mr. Garner, have to go out, get this information, which could be beneficial to you. I really don't think I have a reputation of being disrespectful to anybody that comes in front of me. Until I was disallowed, I've spent every Christmas for the last decade in the jails to visit people like you that a lot of people have given up on.
Yes, sir.
So although I appreciate your apology and I understand you were in a stressful situation, I'm going to put off your sentencing for a while until you decide to fill this out. So the next time this gentleman comes to see you and you say anything to him, that there's freedom of speech. When you get out on the street, you can say anything about me personally that you want to. A lot of people do, I'm sure. Okay. But I don't want you being disrespectful to him or any other officer of the court or any law enforcement officer. He's the one you owe the apology to because he was present. So you can do that publicly now if you want to. And I'm going to reschedule. Go ahead.
I mean sincerely what I told you back there, and I'll repeat it for the court, for the record. I sincerely apologize, man. I was totally detoxing, and I said it out of anger, out of frustration, and really not completely wholeheartedly in my right mind. I sincerely am asking for help.
Okay.
I'll be honored to do it.
That's sufficient. Okay. Well, I'm going to order you to come back here on March the 31st for sentencing. And as far as I'm concerned, you need to listen to me
Yes, sir.
right now. As far as I'm concerned, you can have a fresh start. I'm not a person that holds a grudge, and I don't want to do anything to you that I wouldn't do anything to any other person that doesn't conduct themselves appropriately. But we'll be aware that I do have contempt power,
Yes, sir.
and I can put you in jail without it being good time, and I will not hesitate to do that, okay? Okay, he can be transported back to Adair County when you get ready, okay? Thank you.
This is host.
Mr. Cross, how many people do you have today on the docket?
Hunter, I have several, and I'm also waiting to do a Zoom hearing at Clinton Juvenile, so if you want to pass me that.
Okay, I'll just Commonwealth versus Donna Allen. Donna Allen. Hello. Commonwealth versus Donna Allen. 21 CR 0040. Are you Donna Allen?
Yes, I am.
What's your year of birth
February 29th, 1956,
and the last four digits of the social security number?
9377.
The grand jury of Cumberland County has returned an indictment charging you with trafficking in a controlled substance in the second degree, second offense. 4 counts, and trafficking in a controlled substance within 1,000 yards of school, 1 count. Are you represented by an attorney?
Yeah, I'm getting one. I met with her yesterday, but I haven't got, I'm trying to get my money together to pay her.
Okay, I'm gonna let the office of the public defender's office stand in just for the purpose of arraignment. Who is your attorney that you're talking to?
In your office, old office, Holly Long.
Yeah. So, Ms. Long, you want to stand in for the purpose of arraignment only? You heard Ms. Allen acknowledge her identity. Grand jury of Cumberland County returned this indictment. Mr. Bailiff? Ms. Long, you acknowledge the identity? Receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. The Commonwealth Attorney's Office will hold the reciprocal information until you're officially retained. Ms. Allen, you will be continued on the same bond. You'll be back here on March the 31st for your next appearance. By that time, you will either need to make arrangements with a private attorney or call the public defender's office. And
Thank you.
the sooner you make those arrangements, the sooner they'll give you the information to help you prepare. Okay, thank you very much.
Thank you.
Andrea Anderson. Andrea Anderson.
Your Honor, she needs to be here at 1 o'clock at March 11th, negotiation.
Okay, wait just a second, Miss Allen. What's your March? You need to be here on March the 11th for negotiations, as well as being here on March 31st for your next appearance. March the 11th, March 31st. Andrea Anderson. Commonwealth versus Andrea Anderson. 21 CR 0080. But where did Mr. Cross go?
Like you said, he had a phone call or had to be on Zoom.
Your Honor, I think that Mr. Cross has agreed with Mr. Stockton to negotiate this case on 3/11, March 11th.
And that's an order of searching this one.
Did Mr. Cross say he had a conference call or something? What did he say?
He said he had juvenile case to the conference call. I want to, we can take her when he gets back.
Go back there and have a seat and I'll come back to you. Looks like Mr. Cross is not involved. Michael Birdwell. Michael Birdwell.
He's on the field.
Okay, he's on here. Well, is he in the Dare County Jail?
Yes.
Thomas Brown. Commonwealth versus Thomas Brown.
Judge, can you give us a few minutes? I'm trying to get his medical records off his phone for the prosecutor.
Okay, Christopher Cooksey. Commonwealth versus Christopher Cooksey, 21 CR 00151 yard, Christopher Cooksey.
Yes,
What's your year of birth?
73, 1971,
Last four digits of your social security number.
6319.
What do we have, Mr. Judd?
Your Honor, this is a motion to revoke, but I think that the common attorney has agreed to give him more time to pay, and that correct? Pre-trial conference, I'm sorry.
Yeah, it's a pretrial conference, Your Honor. Mr. Cooksey's been paying the restitution that's owed. He had another $800 to pay on it today. So we were gonna reset it until March 31st if the court was okay with that.
That's agreeable.
Have you paid it already?
No, it's in the public.
He's gonna go downstairs and pay it, Your Honor.
Well, go down there and pay it, and when you get your receipt, just bring it back up here and give it to your attorney before you leave. Come back on March 31st.
Thank you, Your Honor.
Alfred Crescius.
He is signing paperwork, Your Honor. It should be ready. I'll go get it in the room.
Mr. Hurt, do you have Noah Neal?
I do, Judge.
Noah Neal. Noah Neal.
We have a plea on that.
21 CR 00143. You Noah Neal?
Yes, sir.
What's your year of birth?
11598,
For the last four digits of your social security number.
8621.
I understand a motion has been filed that says you wish to enter a plea today. Is that correct?
Yes, sir.
Mr. Hurt, is it a pretrial diversion or a felony plea?
It's a diversion, Your Honor.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Okay, are you the same person named in this indictment?
Yes, sir.
Is your judgment prepared today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed all the evidence the Commonwealth has against you?
Yes, sir.
You understand you do not have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against yourself. No one can make you say anything. You have the right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. You understand by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept any recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher penalty, you have a right to withdraw your plea and proceed to trial. Have you previously been diverted, sir, in the last 5 years?
No, sir.
Do you have any felonies in the past 10 years?
No, sir.
Are you currently on probation or pretrial diversion?
Pretrial, that's it.
Do what?
Pretrial, but for this,
This matter
Yeah,
is
yeah,
pretrial
yeah.
diversion, no previous,
okay,
correct?
no previous.
You understand if you do not complete the diversion program, that you'll be brought back to court and the court would schedule a sentencing hearing, you would be a convicted felon and that could be used against you. You understand that?
Yes, sir.
Okay, y'all step to the left there and let Mr. Judd have the podium. Mr. Judd, what is the Commonwealth's recommendation?
Your Honor, the Commonwealth agrees to amend theft and unlawful taking over $10,000 to theft and unlawful taking over $1,000. And upon a plea of guilty to theft of unlawful taking over $1,000, the defendant shall receive a sentence of 5 years pretrial, diverted for 5 years. Diversion is to be supervised. The defendant agrees to waive his Fourth Amendment rights to search and seizure. The defendant should pay court costs of discretion to court. The defendant shall obtain employment or do 30 hours per week community service. And that's it, John.
You step back over behind the podium. Sir, is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you committed the acts that you're charged with in the indictment?
Yes, sir.
Do you plead guilty of your own free will for no other reason?
Yes, sir.
One of the constitutional rights to explain to you still your desire to enter the plea. The charges allow the court to fix your punishment as permitted within the range of law. You have the document in front of you there, Mr. Hurt. Is that
Yes, sir.
your signature, sir?
Yes, sir.
I'll accept the plea agreement and I will sign the diversion order. Before you leave the courtroom here today, you need to go over with the probation and parole officer. Give him information so he can start the process. Here you go. Over here. Mr. Poindexter, how many people do you have?
I have two, Your Honor, they're both in the Dare County Jail.
Okay. Mr. Hurt, do you have anybody else you want to call that's in the courtroom?
Judge, I appreciate my only other client is incarcerated, Gulf County Jail, where Dare County Jail.
Okay. Okay, thank you, Mr. Cooksey. Alfred Cresilius. Well, Kentucky versus Alfred Cresilius, 22 CR 003. You're here for the purpose of arraignment. You're also here on 21 CR 00136.
Yes, Your Honor, and we have an agreement that
Well,
represents
let
both
me
cases.
arraign you first.
I understand.
Mr. Cresilius, the grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree. Do you understand that charge? Also charging you possession of drug paraphernalia. Mr. Baylor, Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes,
Now, you were about to inform me that you have a global agreement on this thing. Is that
yes,
correct?
Your Honor.
Is this a felony plea?
It is, Your Honor.
Okay. Mr. Casillas, a motion has been tendered by your attorney that says you wish to have a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in these two indictments, which would be 21 CR 00151? And no, correct that, 22 CR 0003 and 21 CR 00136. Is that
Yes, sir.
correct? Is your judgment impaired today in any
No,
way?
sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and you believe you're fully informed?
Yes, sir.
You understand that you do not have to enter a guilty plea in this charge.
Yes, sir.
If the Dare County Jail could turn that camera off till we call the jail docket, I'd appreciate it. Thank you. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against anyone. No one can make you say anything. Right to speed trial, but jury right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. You understand by entering a guilty plea today, you give up all those charges.
Yes,
And I
sir.
may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to put a harsher penalty on you or a harsher sentence, you have the right to withdraw your plea and proceed to jury trial. You understand that?
Yes, sir.
Y'all step to your left, please. Mr. Judd, what is the Commonwealth's recommendation?
Your Honor, the Commonwealth agrees to dismiss possession of drug paraphernalia, and upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 4 years. Upon a plea of guilty to possession of controlled substance first degree, the defendant shall receive a sentence of 2 years. The 4-year sentence in case 21 CR 00136 to run consecutively with 2-year sentence in case number 22 CR 0003 for a total of 6 years, probated for 5 years. Probation be supervised. The defendant agrees to enter and complete a long-term treatment center. The defendant shall pay court costs at discretion of the courts. The defendant shall obtain gainful employment or do 30 hours of community service. And the defendant agrees to having no drug paraphernalia and contraband disposed of in accordance with the laws of Kentucky.
Is that your understanding of the Commonwealth's recommendation? Has anyone, including your attorney, offered you any other recommendation or benefit to enter a guilty plea?
No, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Plead guilty of your own free will and for no other reason?
Yes, sir.
Knowing your constitutional rights, is it your desire to give them up and enter this plea and allow the court to fix your punishment and arrange permitted by law? You understand that after entering this guilty plea, any future convictions could be enhanced as far as the penalties.
Yes, sir.
Is that your signature on the offer?
Yes, sir.
I accept the agreement or pre-sentence investigation report done for you to be back here on March the 31st for the purpose of sentence.
Thank you.
I thought you had him in custody. Come around, Mr. Booth. You're right out here. You raise your right hand, sir. You solemnly swear or affirm that you conduct your duties as a member of the grand jury of the Cumberland Circuit Court. Do you keep all matters confidential that you hear therein, that you will protect and defend the Constitution of the Commonwealth of Kentucky and the United States of America? So help you God. Thank you very much, Ms. Beth. Clerk will lead you around. Charles Dyer. Now, he has an active warrant now. You might consider NCIC for that.
Yes, Judge.
Edsel Elliott. Mr. Elliott. Commonwealth of Kentucky versus Edsel Elliott, 21 CR 0046 and 21 CR 0047. You are Edsel Elliott.
Yes, sir.
Are you represented by counsel?
Not this time, but
Okay,
I'm working on getting.
okay, well, I'll let the public advocate stand in for the purpose of arraignment.
Yes, sir.
Ms. Costello, you heard Mr. Elliott acknowledge his identity. What are the last four digits of your social security number
9094
and your year of birth?
11/13/55.
You're here for the purpose of arraignment, Mr. Elliott. You have the right to remain silent. I suggest that you exercise that right until
Yes,
your
sir.
counsel. The grand jury of Cumberland County has indicted you with charge of trafficking and controlled substance in the first degree. The persistent felony offender on that charge. There is 21 CR 0046. And on 21 CR 0047, the grand jury has indicted you with trafficking and controlled substance in the first degree and being a persistent felony offender. Those are those charges. Mr. Bailiff. Mr. Elliott. Mr. Elliott, you acknowledge you received the indictment. Now, don't give her the discovery yet because she's just doing the arraignment.
Yes, sir.
Okay, I'm doing two reciprocal discovery orders. Mr. Elliott, you are to be here on March the 11th with an attorney for negotiation purposes. And again on March the 31st.
Yes, sir.
Both of those are conditioning your bond.
Yes, sir.
Okay?
And as you enter, please not guilty on this behalf.
Coletta Espinoza. Commonwealth of Kentucky versus Coletta Espinoza, 21 CR 0045 and 21 CR 0044. Are you Coletta Espinoza?
Yes, Your Honor.
Okay, leave your mask on. Are you represented by counsel today?
I'm not currently represented by a counsel. I am currently gathering money to pay.
Okay, well, I'll let the public advocate come up and begin. You're here for the purpose of arraignment. You have the right to remain silent. I suggest you exercise that right. Grand jury of Cumberland County has charged you with trafficking and controlled substance in the first degree. In indictment number 21 CR 0045. And has also charged you with criminal conspiracy to, just drop it there. Criminal conspiracy to trafficking and controlled substance. Do you understand those charges?
Yes, Your Honor.
You acknowledge, excuse me. You acknowledge identity of client or plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing reciprocal discovery orders, Ms. Espinoza. That when you get an attorney that can get all the discovery that the Commonwealth has to help you prepare for your case. You're to be here on March the 11th with an attorney.
Yes, sir.
If you don't find another attorney, the Office of Public Advocacy will give you their information. The next date after that is you to be here in court on March 31st. So you have two dates, March 11th, March 31st. Both of them part of your bond. Okay,
Yes, Your Honor.
thank you.
Thank you.
Oscar Fairley. Good morning, Mr. Fairley.
More.
It's 19 CR 0089. We're here on a revocation. You are Oscar Fairley. What are the last four digits of your social security number?
5643.
Year of birth.
92.
Okay, what do we have, Mr. Judd?
Your Honor, this is a motion to revoke and impose sentence.
Okay. Tell me what it is.
Sorry.
Present your case.
Yeah, I'd
Your
like to
Honor,
call
if,
Mr.
if I may, am I representing Mr. Farley or does he have private counsel? They're both listed.
It says DPA here.
If I could have a minute to talk to Mr. Carter, Your Honor. He was out of custody and not in on this, so I have not.
Okay, step over there and do it. Cromwell versus Dwight Harold. Says there's an active warrant on Mr. Harold. Is that correct? He's not been served. I'm not going to consider him for NCIC. Reese Tessa Humphrey. Commonwealth of Kentucky versus Tessa Humphrey. 21 CR 00153. Are you Tessa Humphrey?
Yes, sir.
We're here for the pretrial conference.
Your Honor, Ms. Humphrey was in custody last time and was not ordered. And didn't get the information to be here on our settlement conference day. She was also not ordered to be there that day. It just kind of slipped through. So I was gonna ask for another settlement conference for Ms. Humphrey. I've talked to Mr.
That's
Stockton.
real with Commonwealth.
March the 11th. Next court date is March 31st. James Hurst. James Hurst. Come on up, Mr. Hurst. Commonwealth of Kentucky versus James Hurst, 22 CR 0013. Are you James Hurst?
Yes, sir.
You have an attorney?
Yes, I talked to David Marshall yesterday.
Talk to who?
David Marshall. He's out of Lexington.
He's not here today. is he?
Well, he said, I just retained him yesterday. I go send some papers up about the bond, for the bond to be released to him, for payment.
I'll let the Office of Public Advocacy stand in for the purpose of arraignment. This is a pretrial. Commonwealth of Kentucky versus James Hurst. Brett, you have a right to remain silent. Grand jury of Cumberland County has returned an indictment charging you with theft by unlawful taking. Class D felony. Understand the charge?
Yes, sir.
Counselor, you heard this gentleman acknowledge his identity. Juries, you'd like to enter a plea for him of not guilty, reserving all pretrial motion.
Yes, Your Honor.
Sir, you shall be back here on March the 11th for negotiation with your attorney. And then back in court on March 31st. Both of these are condition of your bond.
Yes, sir.
At that time,
Sorry, so you're under secured bond, sorry.
I got a bond, $5,000 bond up and something else here.
Okay.
Yes, sir.
Did you say something else?
Yes, sir.
What's the other?
Trafficking. Yeah, it's the same, it said the day they arrested me for the theft of the vehicle, they got a trafficking charge on me too. I got 5,000 cash up on him.
Okay.
And he did appear in, I don't represent him on that, Your Honor, but I do know he was in court yesterday.
Yeah,
for
I
his
appeared in court on it yesterday.
district court.
Yes, Your Honor.
Well, this says $15,000 surety bond.
On this case, and
Yeah.
the 5,000 cash is on the district court. case.
On the district court, I'm sure it'll probably be approved for it. That's why I was talking about.
Wait,
I'm sorry.
Now, here's the deal. If he's got, is this gentleman going to represent you on both these?
Yes, sir, that's why I was talking about the bond money.
Okay, well, here's the deal. You need to give him he needs to get all the information. When you come here on March 11th, you need to be prepared to negotiate both those cases.
Right.
And they can proceed with the case in district court by information.
Let me go down and get it from there.
No, you don't need to do anything. You need to get a lawyer.
I got one.
Well, no, you don't have one.
Okay.
You need to get a lawyer, and when they call you, the Commonwealth Attorney's Office, to get to discovery and other things, Mr. Judge, we all make a note to bring up this district court case to him so you can negotiate all of them. You're to be back here on March the 11th for negotiations in March 31st. And I want to make that $5,000 and $15,000 surety stand for both of these cases, okay? Since they'll be negotiated together. You understand that? You understand it?
Yes, sir.
Okay, thank you. April Nethery. April Nethery. What did I do? No one deals with custody except like I said.
No, no one knew. She did give her a plea.
I didn't mark him off. Commonwealth versus April Nethery.
On person Friday, and she's supposed to be here yesterday and today, and she don't appear in this report yesterday also.
Issue a bench warrant without bond. Now, from here on out, when I issue these bench warrants, make sure we put without bond, because some people have been getting out on the low bonds, okay? Michael Nethery.
He got picked up last night, so he's in the jail.
Amanda Reynolds. Will you knock on the door and see when Mr. Cross is gonna be available? You can go ahead and have a seat back out there, man. Jeffrey Reynolds. Cromwell versus Jeffrey Reynolds, 21 CR 0074. This is a hardship license here. Are you Michael Nethery? I mean, are you Jeffrey Reynolds?
Yes.
What's the story on this?
Your Honor, I didn't file this. I think Mr.
I filed
Reynolds
it. Yes.
requested it. I did represent him prior, so I stood up with him.
What do you have to say, Mr. Judge?
Your Honor, if he's trying to help himself, is to get to a job,
Yes, I'll be working for White House Sober Living in Elizabeth.
Raise your right hand, please, sir. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes,
where do you live?
I live in Elizabethtown at the Sober Living.
Your Honor, I don't think that the Commonwealth does not oppose him. We have a good license. just to-
Have y'all reviewed his application, see if he's qualified? I don't do very many of these things. I do none of them, as a matter of fact. So if I approve it, what was the underlying charge here?
DUI second offense. I've already done over a year on my suspension now.
He had a possession charge and then the DUI second, Your Honor. And the initial charge was September of 2020, so he has made lots of headway onto his suspension period.
How long were they originally suspended for?
A year and 6 months.
And how long's it been?
I believe he entered the plea in August, so he has, but it was suspended prior to that because it was a DUI second. So he should have almost a year in on his suspension.
A year and like 3 months, a week after I was charged.
Okay,
with
I
the
will,
stuff they suspended me on.
sign the order. But for a hardship license only. Okay, thank you very much.
Thank you, Your Honor.
Where is the file? So you need to take it with him?
How long after that should he go and try to get one?
Okay.
So we go downstairs.
Here's just a way, let me get one done.
Now, there's certain requirements as far as driver's education, employment, and those sort of things that you'll have to meet. You understand that?
Yes.
I have to write on that order, like what days you want to drive.
What days you gonna work?
I'd be working Monday through Sunday. I mean, it's every day that I'd be driving for the sober living,
For the what?
the sober living program. I'd be doing transportation for them.
He's working at the. He lives there.
What kind of transportation you gonna be doing for them?
Taking people to and from meetings, to and from work, doctor's visits, anything like that. I actually put on the application, the insurance for the sober living, like vehicles and stuff too, because I would not be using my personal vehicle for that.
Those are.
Okay, go ahead and include those conditions, Monday through Saturday for trips for sober living only. Okay. Okay, thank you. Caitlin Riddle,
Robert, did you call the Reynolds case?
I did,
You wanna take-
but I'm gonna do Caitlin Riddle right now. And are you ready to start your cases?
I'm still not getting out here and get on.
You still what?
I'm still awaiting to get the call. No, I'm not.
Commonwealth versus Caitlin Riddle. 22 CR 0014. Are you Caitlin Riddle?
Yes, Your Honor.
Are you represented by the Office of Public Advocacy?
Yes,
Yeah. What's your year of birth?
2001,
Last four digits of your social security?
4568.
You're here for the purpose of arraignment. You have a right to remain silent. I suggest you exercise that right. The grand jury of Cumberland County has returned an indictment charging you with possession of a controlled substance in the first degree and possession of drug paraphernalia. Mr. Bailiff, you understand those charges?
Yes, Your Honor.
Counsel, you acknowledge the identity of your client, receipt indictment, waive formal reading, and writing, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing reciprocals discovery order. The Commonwealth has given you information concerning your case. You're to be back here on March the 11th for negotiation and March the 31st for your next court appearance. You understand that? Both of those are conditions of your bond.
Thank you.
Tanya Robidoux. Is it Robidoux or Robidoux?
Robidoux.
Robidoux. 21 CR 00134. So other hearings, what it says on the docket.
Your Honor, I think the problem, after speaking to Officer Garner, was that Tennessee at first denied the transfer, not for any fault of Miss Robidoux's. She is in a relationship with somebody who has a prior felony, but they have a 10-year-old child and have lived together for over 10 years, and that's not something Kentucky would reject on. And then Tennessee, so Mr. Officer Garner has actually contacted Frankfurt for them to look into an investigation as to why Tennessee rejected her, because they really shouldn't have.
Your Honor, I submitted the transfer through Interstate Compact on January 4th. It was denied on February 11th. The reason for the denial involved a serious inquiry into taxes and trying to break up her family with a son of 10 years old. That's something the Commonwealth wouldn't do. So I launched an investigation with Frankfurt into the reason why Tennessee is going above and beyond. And we agreed that we would resubmit the transfer, and I resubmitted that on 2/14. Because of the investigation, they've prolonged the transfer response time till March 31st. So I won't know if it'll be accepted by then. or until then.
You will know by March 31st.
Well, they have to March 31st to respond to the transfer, Your Honor.
Okay, well, we'll take this back up on April the 28th. And you can take it off the docket with agreement of the Commonwealth if the transfer takes place, okay? Don Rodriguez. Commonwealth versus Don Rodriguez, 22 CR 0007. Are you represented by counsel, Mr. Rodriguez? What's your year of birth?
1980,
Last four digits of your social security.
31.
I'm gonna let public advocate stand in for the purpose of arraignment. Are you planning on getting an attorney?
No, for 21.
Do what?
A court appointed one. A court appointed one.
Do you have a job?
No, I get disability, sir.
Okay, I'm gonna appoint public advocacy to represent you. The grand jury of Cumberland County has returned an indictment charging possession of a controlled substance in the first degree, possession of marijuana, possession of drug paraphernalia, license to be in possession shown on demand, inadequate silencer, and careless driving. Counselor, do you acknowledge the identity of your client? Proceed indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
You'll be back here on March the 11th for negotiations and March 31st for your next court appearance. Both of those are condition of your bond, okay?
Yes, sir.
Thank you.
Emmanuel Santiago Vega. Commonwealth of Kentucky versus Emmanuel Santiago Vega, 21 CR 0042 and 21 CR 0043. Are you Emmanuel Santiago
Yes, sir.
Vega? What's your year of birth?
1982,
Last four digits of your social security number.
451,
Say that again.
2451.
Okay, do you have an attorney?
No,
Can you afford an attorney? Do you have a job? What do you do? What do you do for a living?
I'm an SSI and I need just time to get my attorney, her money. I just need a little time.
Okay. I'm gonna let the public advocate stand in for the purpose of arraignment. The grand jury, you have a right to remain silent. I suggest you exercise that right. Grand jury of Cumberland County is charged you with trafficking a controlled substance in the first degree, first offense. That is in 21 CR 0042. And in 21 CR 0043, the grand jury is charged you with trafficking and controlled substance first offense again. You understand those charges?
Yes. Yeah.
Mr. Bailiff, you present those. Counsel, you, for the purpose of standing in here, do you acknowledge the identity of Mr. Santiago Vega, the receipt indictment, late formal reading and arraignment, enter plea of not guilty?
Yes, Your Honor.
Now, Mr. Santiago Vega, so you plan on hiring a private attorney?
Yes.
Okay, well, you have that attorney here on March the 11th for negotiations. If the attorney will contact the Commonwealth Attorney's Office, they'll give them the information concerning your case. I've just signed 2 reciprocal discovery orders, and the attorney, once they identify themselves, can pick that information up to help you prepare for your defense. So you'll be here on the 11th and the 31st. Both of them are conditions of your bond.
All right, thank you.
Patrick Sharp. Commonwealth Kentucky versus Patrick Sharp, 21 CR 0053. Are you Patrick Sharp? What are the last 4 digits of your social security number
4954,
and your year of birth?
96,
Do what?
96.
1996. Okay. Do you have an attorney?
No.
Okay. Are you gonna hire a private attorney?
Can I get a public defender?
Do you have a job?
Yes.
Where do you work?
Tyson?
Okay, and you own a car?
Yes.
You own a house or anything?
No.
Okay, you can fill out a form. What's your monthly income?
I'm trying not average it out. So.
But I'll let you fill out a form. Got any of those public defender forms?
No, I have represented him in the past, if that helps.
Well, he might have improved his financial circumstances since then. You might have given him a new lease on life. She could stand in for the purpose of arraignment. The grand jury of Cumberland County has returned an indictment charging you with trafficking and controlled substance, first degree, first offense. Do you understand that charge? So you acknowledge the identity of Mr. Sharp, receive the indictment, waive formal reading and arraignment, and your plea of not guilty.
Yes, Your Honor.
You'll be back here on the 11th of March for negotiation and the 31st of March for your next appearance. I'll review this application at the end of court here. See if you're up.
I'll have him fill it out. Your Honor.
Joseph Slayton. Joseph Slayton.
He is incarcerated back.
Mr. Slayton is incarcerated in Barron County. There's an active warrant out for him. I don't know where that's been served. It's been served. Now, we weren't able to get Barron County to do Zoom with us today because they had district court at the same time, and I think he was supposed to be in district court. Is that correct? So I'll continue his case till March 31st. And if the Commonwealth will inquire at the time to see if we a few days beforehand to see if he's going to be available to Zoom. If he's not going to be able, then I'll get a transportation order. Okay. That's your client. Ms.
It was,
Costello.
Your Honor.
You get involved in that too about getting here. Okay.
Yes, Your Honor.
Vivian Stahl. Commonwealth versus Vivian Stahl, 21 CR 0052. Are you Vivian Stahl?
Yes, sir.
You have an attorney?
No, I need a public defender, please.
Do what?
I need a public defender, please.
Do you have a job? Are you on
No,
disability?
I'm waiting on my disability.
I guess in the way we all are. What public advocate represents you? Ms. Stahl, you're birth 1979?
Yes, sir.
What are the last four digits of your social security number?
3331.
The grand jury of Cumberland County has charged you with trafficking and controlled substance and second degree.
Yes, sir.
Counselor, you acknowledge the identity of this lady?
Yes, Your Honor.
Looks like there are two cases here. No. that's not. You acknowledge receipt of the indictment, waive formal reading and arraignment, and your plea of not guilty.
Yes, Your Honor.
I was handed two reciprocal discovery orders, which were confused me for a second. The other one's for Patrick Sharp. And I'm signing a reciprocal discovery order, which means the Commonwealth will deliver a package of information concerning your case to help you prepare for it. You'll be here on March the 11th. March the 11th for the purpose of negotiation, and March 31st is your next court date here. Both of those are conditions of your bond. Do you understand that?
Yes, sir.
Seth Staley. Well, Commonwealth versus Seth Staley, 21 CR 0050. You are Seth Staley.
I am, Your Honor.
Okay, what are the last four digits of your social security number
7119
and your year of birth? Do
62177.
you have an attorney?
No, I draw disability.
Okay, I'll appoint a public advocate to represent you. You're here for the purpose of arraignments. You have a right to remain silent. The grand jury of Cumberland County is charged with trafficking and controlled substance, second degree. You understand that charge? You understand it?
Yes.
Okay. Counselor, you acknowledge the identity of your client, proceeding indictment, away from one more reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Mr. Staley, I'm signing a reciprocal discovery order here. Provide information. You're to be here on the 11th of March for negotiation and 31st of March for your next court appearance. Both of them are conditioning your bond. Do you understand that? You understand that?
Yes.
Okay, Amy Stinson, Amy Stinson. Amy Stinson. Commonwealth Kentucky versus Amy Stinson. 21 CR 0048. Are you Amy Stinson?
Yes, sir.
You're here for purpose of arraignment. You have an attorney. What is your year of birth
1981,
and last four digits of social security?
5671.
Why don't you have an attorney today?
We can afford one.
Okay, do you have a job?
Huh?
Where you work?
I clean houses.
You own any property or anything? Okay, what's the Office of Public Advocate? Represent you. This is for arraignment. You have a right to remain silent. The grand jury of Cumberland County has charged you with trafficking and controlled substance. First degree. You understand that charge?
Yes, sir.
I'm about to sign a reciprocal discovery order. The Commonwealth is going to give you some information. If you prepare for your defense, you shall appear in court the next time on March the 11th here for negotiation at the courthouse. And the next time you're to be in court itself is on March 31st. It's 2 days. Remember, both of those are conditional your bond. You understand that?
Thank you.
Ashley Stotts. Commonwealth versus Ashley Stotts, 21 CR 0050. You're here today for a pretrial conference. What you got?
Your Honor, I got in this case the day before the negotiation session, and there are records to review regarding the allegations. We're just in the process of doing that now.
March the 11th for negotiation and March 31st, next quarter.
Your Honor, I would note that I will be out of the area on March the 11th, but I'll make arrangements to meet with Mr. Stockton prior to March 31st.
That's okay with the Commonwealth.
Can you do it prior to the 11th or?
I'll do my best. Okay.
Commonwealth versus Brian Thompson. Commonwealth versus Brian Thompson, pretrial conference.
We've got an agreement.
Is it a felony plea or?
It's a felony plea.
A motion has been tendered. Mr. Thompson says you wish to enter guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
That's right.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment 20 CR 00066?
Yes, sir.
Judgment prepared today in any way?
No.
Have you discussed this matter with your attorney and you satisfied with his advice?
Yes.
Are you familiar with the evidence that Commonwealth has against you and you feel like you're fully informed about the case?
Yes.
You realize that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand these rights.
Yes.
You have a right not to testify against anyone. No one can make you say anything. You have a right to speed trial by jury. You have the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to file a comma prove beyond a reasonable doubt that you guilty charge against you. You understand that by entering guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will review the pre-sentence investigation report on probation and parole. In the event that I do not accept their recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. We all step to the left here and let Mr. Judd recite what the plea is and see if this is what you agree to, Mr. Judd.
Your Honor, the Commonwealth agrees to dismiss 4 charges are possession of drug paraphernalia, motor vehicle insurance to be in paper or electronic format, reckless driving, and speeding. Upon plea of guilty possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years probated for 5 years. Probation is to be supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance, the defendant shall pay a fine of $200 plus court costs. The defendant agrees to be assessed by the Social Service Commission with following recommendation. The defendant shall pay a fine and court costs at discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week community service. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of Kentucky. The defendant shall remain on active supervision until any all fine and court costs are paid in full and further request probation parole.
Is that what you agreed to, sir?
Yes, sir.
In addition to being enhanceable as far as the felony is concerned, the DUI that you entered to is also enhanceable. If you get an additional DUI, it will be more serious than the one you have now. You realize this could be used against you in future DUI, okay? Now, do you plead guilty of your own free will because you did commit the acts in the indictment as amended?
Yes.
Is it still your desire to go ahead and give up these rights by entering a guilty plea and allow the court to fix your punishment?
Yes.
Is that your signature on the motion and offer?
Yes, sir.
I'll accept the agreement, order pre-sentence investigation report done. You'll be back here on March 31st for your sentencing, okay? Andrew Weiss. Do what? Yeah, let me see the financial statement. I'm going to appoint public advocacy to represent Mr. Sharp and impose a $500 fee on him, okay? So he should pay $500 to public advocacy.
Thank you, Your Honor.
Well, he needs to, he hadn't signed this under oath yet.
Oh, you want to call that?
Have him come back up. Sir, you step over to the right there. Swear the testimony that you gave and the information you put in the order of application for public advocate is true and correct. I'm going to appoint a public advocate in order you pay $500, okay?
Oh, that
He
one.
needs to sign this affidavit. Pay that before your next court appearance on March 31st, okay? I
Before
guess
the 11th or the 31st, Your Honor?
31st. 11, probably running a little short. The case before that on the DUI and stuff, we didn't mention the amount of fines. We do that. So. Okay, you can go now. Mr. Weiss. 22 CR 0011, 21 CR 0012. You're here for arraignment on the new charge. You're represented by counsel. You have a right to remain silent. I suggest you exercise that right. The grand jury of Cumberland County has returned an indictment charging you with trafficking and controlled substance over 2 grams, Class C felony, possession of drug paraphernalia. Operating motor vehicle with expired plate. Possession of marijuana. You understand those charges? Sign a reciprocal discovery order here. It gives your attorney certain information to prepare for your case. You should be here on March the 11th for negotiations and March 31st for the court appearance. Both of those are conditions of your bond.
Gunner, he has the next case too. That was off the pretrial. I had spoken to Mr. Stockton and he knew about this arraignment. So he wanted them both reset for the settlement conference in March to discuss them both.
It'll be fine.
Thank you.
You have Thomas Brown ready now? You're Thomas Brown.
Yes, sir.
Here for review, it says.
Yes, Judge, you had asked us to come back to make sure that he had.
Ms. Costello?
You had asked us to come back before the court, Your Honor, to verify that he had done his home incarceration and basically was behaving. There was a case in Barron County, which was unrelated to this one, but they followed this court's direction in giving him home incarceration. I guess the court wanted to review to make sure that he was still doing that.
Your Honor, it's my understanding that the defendant was supposed to supply his medical records, and I have copies of where he saw the doctor, but I don't have any records. Is that true?
He didn't show up, was that it? What was
No,
it?
he was at the doctor's office on January.
Oh, here, why do I want his doctor's records? I've forgotten. Megan, do you remember this case?
No, I don't.
Why was I asking for his doctor's records?
I think the prosecution asked for him, Judge.
For what purpose? Did he not show up? or was
No,
he-
Judge, he had had some injuries, and I think they wanted verification that he was had the conditions that he said he had. But he's been going to plastic surgeons and what are the other doctors? Neurosurgeons, because he had a head injury, and that's the basis of the court's decision to put him on home incarceration.
Your Honor, what I have, there was a motion to revoke this. It's been stated as a sanction, the defendant shall serve 60 days home incarceration. The defendant shall also undergo a medical evaluation. The matter shall be reviewed today. It's February 24th, what it said.
And as far as I know, Judge, he is still treating with those.
Well, I know, as far as you know, but I don't have any evidence.
Can I put him under oath?
Well, you know, why don't we have any medical records?
Judge, I had spoken to him last time about this, and I've got, he says he can fax them, but
But today was the day you're supposed to have.
Well, I think, Your Honor, that you told me to go ahead and go out of the courtroom before the prosecutor and my lawyer had spoke about this. Because you gave me the 60-day sanction and told me you wanted it monitored by probation and parole. And you told me you can go, and I think maybe they were discussing that as I left the courtroom. Because I didn't hear that.
I think the prosecutor asked for those while we were inside the courtroom. But he is still treating with,
But I can fax them over there today.
I want you back here on March the 31st and back on the 11th. Are you gonna be here on the 11th negotiating
I think so,
cases?
Judge.
Okay. I want him back here on the 11th. That way, Mr. Stockton will be present. Y'all can discuss where we were on this case before the 31st. Maybe avoid him coming back on the 30th.
Yes.
Okay.
So if we can get that worked out, Judge, on the 11th, we can take it off the docket on the
Well, Mr. Stockton, you by agreed order can
Yes.
take it off the docket. If
Yes.
not, he's on the docket for the 31st,
Thank you, Judge.
11th and the 31st.
Thank you.
Yeah. Oscar Fairley. You had an opportunity to talk to Mr.
I have, Your Honor.
You pronounce yours Farley or Fairley?
Fairly.
Fairley, okay. We're here for a revocation here.
I've spoken to Mr. Judd, Your Honor, and he was okay with the referral for drug court, if the court was.
What was the revocation? What was,
Basis, Your Honor?
yeah,
He had been, based on the positive drug screen, he was sent to treatment where he was removed from treatment for smoking a cigarette. So we sent him to another treatment. And then he left that treatment as well. That one was voluntary. He's got,
Ms. Stone, will you turn your camera off to your case's call?
she is the officer.
She's the officer, okay, I'm sorry. This is your case. She was a supervising officer?
At the last treatment facility, Your Honor.
Yeah. Will you want to stipulate?
Yes, Your Honor, he stipulates that he left treatment.
We'll stipulate, and can Ms. Stone be excused then? Stone, thank you for appearing today. You can be excused. He is stipulated, okay? Okay, I'll sign a referral to drug court. You smoked a cigarette and what else?
Your Honor, the first time he was caught smoking a cigarette in the facility, so they discharged him, and DOC didn't fully agree with that, other than he did break the rules. But we sent him, or we requested to send him to another treatment facility, and we sent him to the Mark Center in Lexington.
It was the Jacobs House in Lexington. Mark Center was involved there. Well, the Hope Center was in, they call it the Jacobs House and the Hope Center in Lexington. Because the Mark Center was in Bowling Green.
What was the problem there?
The Mark Center was probably got kicked out with smoke.
What was the problem in Lexington?
In Lexington, man, I watched them pet, I was there for like 8 days, and I watched them pet 3 people out in body bags from overdosing on fentanyl. I mean, it's more, I was like I was on the streets there.
So you left to your own accord there?
Yeah,
And he reported back to his officer.
yeah, I called Jeremy.
Okay, well, I'm gonna try you in drug court. And seems like you've been straight up. So I don't give up on anybody very easily, but you need to finish this drug court, work on it really hard, try to get yourself going, okay?
Yes, sir.
Okay, I'll sign the referrals. Who will he need to stay? Will he need to meet with Mr. Murphy or anybody concerning the?
He'll have to be obsessed by Mr. Murphy. And I think he's fine with staying in contact with probation and parole until he's accepted. If the court orders him,
I'll monitor him until he's accepted.
Okay, that'll be fine.
Maybe more, I think that. Where do I go?
it's right. I'll take it.
So you're still under his monitoring until you get into drug court. Okay?
Thank you, Your Honor.
Okay, I won't schedule it again. Hope I don't see you back up here on this, okay?
Thank you.
Awesome. I need the phone number.
Andrea Anderson. Commonwealth versus Andrea Anderson, 21 CR 0080 pretrial conference. Do y'all have a motion in this case?
Your Honor, we would like to set up a renegotiation with Mr. Cross. I don't think we've done it, have we?
No, my office has advised, we got an opinion this morning from you overruling it. Was it one of her cases? What, is the other one been ruled upon yet?
I've got it here.
Okay. Of course, we'll have to have an opportunity to review it and see where we are on it. So, but yeah, we'll have to negotiate.
March 11th
Okay. And again.
and March 31st.
Okay. So where do you think? Your Honor, I think Ms. Reynolds.
Michael Birdwell is in jail. Amanda Reynolds.
The same, Your Honor. My office says the order came in this morning, so we'll.
11th, Ms. Reynolds, the 11th for negotiations, and the 31st.
Wait for me.
Okay, Commonwealth of Kentucky versus Joseph David Arms. The defendant's motion suppresses over. Okay.
Your Honor, I filed a response in regard to that, which did you have an opportunity to review our response?
When did you file? When did you file one?
Well, they filed their motion at 3 o'clock yesterday afternoon, and I filed my response at 3:15. So, you know, and we picked up the.
Well, when were you supposed to file it by?
Oh, no, I haven't filed a brief. Your Honor, we filed a response. I asked until, I believe, the 3rd to file it. I actually thought, I'm not going to throw my associate under the bus, but I actually thought this had been done. So if you'll give us till the 3rd to submit that. The response said we picked up the tape only on February 17th. Response basically says what we're. And we had talked with Mr. Stockton about this on more than one occasion. It's not that it was, nothing was happening.
Well, you need to have your client available on the 11th for negotiation. Be back here on the 31st. And I'll review your response and
We will get that filed, Your Honor. Almost immediately. Thank you. And I apologize for the delay, but it wasn't that we hadn't had any communication.
yeah. Is there anybody else on the live docket?
We got some of their things, I think two is not.
What are these? These are their cases.
Yeah.
Yeah. The Dairy Circuit Court will come to session here. I have a case of Commonwealth versus Brandon Jones. Is Brandon Jones here?
He's in the County Jail, John.
Here he is, Judge. Is anybody here live from
James Boyd.
Commonwealth versus James Boyd, then. Eighteen CR 0068. Commonwealth versus James Boyd. We're here for a plea, is that correct?
No, Your Honor. I'm sorry, we do not have an agreement in this case.
When was your trial set in this case?
The 18th, Your Honor. I think Mr. Wright had some availability issues and I had not spoken to Mr. Boyd.
Last Friday.
It was supposed to be last Friday.
Yeah.
You have their docket, their court, you have judge's docket from up there, your docket.
No, she emailed me one, but I thought she had maybe emailed that to everybody, so I didn't print it out, but I can. Look at it for you.
But you have the courtroom availability, so I'm.
Oh, I thought you had a docket sheet for the day.
No.
Yes, I should have the courtroom availability, I think.
What kind of case is this?
It's a marijuana cultivating and charge of trafficking case of what, a few hundred plants maybe.
What was the offer on?
5 probated for 5.
Years, probated for 5 years.
Is he eligible for pretrial diversion?
I don't honestly know if he is.
He is.
Can I speak?
No. I'd love for you to, but you might say something to hurt yourself, and I don't mean to step away and talk to your lawyer about it. Is Commonwealth willing to offer him a pretrial diversion?
I'd like to speak with the sheriff, who's the investigating officer. That's something that I would discuss with him. So long as he doesn't have some compelling reason to oppose it, we might consider something like that.
Step away and talk to your client just for a second.
One trial date.
But can we go talk a minute?
This has been 4 years of harassment. Your Honor, it's pre-warrant
I'll
evidence.
set your trial date.
It's pre-warrant evidence.
Don't
Your
say
Honor.
anything else. I'll set your trial date. You got a right to do that. I was just trying to ease you out of it. Okay, but you don't need to say anything. Okay? I'm gonna give you a trial date.
Your Honor, see, if we're gonna go to trial, Ms. Costello is unwilling to work this case. There's been Brian White stalled this case for 26 months after I filed a complaint with the FBI about missing evidence. For 26 months, it's disappeared from the docket. It's been nonstop. I got 30 phone calls from her since 10. First, she started out with, we're gonna change the trial date. And I said, I'm not okay with that. I wanna go in front of the judge. And then I got a barrage of voicemails on Tuesday trying to get me to take a plea bargain. She won't return my phone calls on when my court date is. I was told to be in Adair County this morning. 5 minutes Costello. I called her at 7:30 this morning. She told me to be here. She's never returned my phone calls about the trial being cut off or nothing. It's just been a barrage of I have to take a plea bargain.
I'm fixing to set your trial date. It's direct.
Can I speak at trial? Or do I have to rely on her?
You have a right to testify at any trial you want to,
Thank
even if it's against the advice of counsel. I was watching this movie the other night, and I guess Making of Anne or something, whatever it was, and it was in New York, and saying we wasn't going to let her testify. The attorney wasn't going to let her testify. That doesn't happen in Kentucky. Even if it's not in your best interest, if it's your decision to testify, you will be allowed to testify.
I'm willing to take that route, Your Honor, because nobody's willing to defend me in this.
Well,
there's multiple city
okay, I've
employees
heard
involved in
enough.
it.
Okay, I understand you're not pleased with her representation. Now, do you want to withdraw from the case and allow somebody else, or how do you feel about it?
Your Honor, if Mr. Boyd hires another attorney, then I can withdraw, but we are appointed until that happens.
Yeah. Well, if you want to hire a private counsel, I will allow you to do that.
I hired one before and he wouldn't, he did the same thing. He even sent one of his
I don't
clients.
want to
to
hear
say
a
that.
diatribe from you. I'm just telling you, I'm giving you an opportunity to have private counsel.
Another issue is.
I don't want to hear anything else from you. You understand me?
Yes, Your Honor.
Look at June the 1st or 2nd.
Judge, as far as, I don't have anything scheduled. So that would be the.
Wednesday or Thursday.
Wednesday, Thursday.
Now, which is a better day?
Excuse me.
Which day does Judge Vance Murphy have?
Most of our rule days, motion hours are on Tuesday.
So,
June
so if I did June the 1st, then I'll hold the 2nd in case it takes more longer.
Yeah, there's nothing criminal set for either of those days. Now, if she has anything civil, I wouldn't know that. But criminal docket is.
I think those are open because I think
Well, they
so.
got plenty of courtrooms up there, for sure.
Oh, yes, yes. Just be, as long as there's not a civil jury trial would be the only thing.
I don't
I
think
would be
that-
so shocked if there is, but.
Okay, I'll schedule the trial for June the 1st. Now, before this gentleman leaves today, why don't you see if you can make an appointment specific to try to improve the way he feels about communications, okay?
Yes, Your Honor.
Thank you very much.
If pretrial diversion is something you want to entertain, let me know.
And we have 2 folks in the jail up there. We have no one else live here today, do we? Okay, well, we'll go to the Dare County Jail then.
James Drew Griffith, I believe, will be here live with his attorney Cameron Griffith, but he is running late from court in Casey County in Texas. He's on his way. Cameron will be here.
So you got one case, this Brandon Jones.
Brandon Jones is, he's on the screen.
Commonwealth versus Brandon Jones.
That's Mr. Stone's client.
Good.
We probably need to go back there. Is there public advocacy computer set up back there? You got Brandon Jones on the tube here.
Oh, I don't have one. I usually use the courtroom, Your Honor.
Okay, well, we'll usually do that.
Oh,
This is Commonwealth versus Brandon Jones, Adair Circuit Court Action Number 21 CR 0033 and 21 CR 0034. Is that right, Mr. Wright? Just 2 cases.
That's correct.
Are you Brandon Jones, sir? Mr. Jones, can you hear me? Brandon Jones?
Yes, sir, I can hear you. Yeah, I can hear you, sir.
Wait just a second, Mr. Jones. Somebody needs to turn Mr. Jones' microphone on.
Yeah, I can hear you, Mr. Williams.
I still don't have any sound from Adair County.
I can hear you, Judge. We live, Your Honor.
Mr. Jones, could you try to say something again?
Yes, sir, Mr. Judge, I can hear you.
We got some kind of problem here. Which we need to get straightened out now because we got this jail bar. How about now, Mr. Jones?
Yeah, I can hear you, Mr. Judge.
I can hear you fine. It's your computer.
Judges, Pulaski County, can you hear us?
This is Taylor County. We can hear Pulaski and Adair.
You try to say something now from Adair County? Can you
We're
hear
here,
me, Mr.
Judge.
Jones?
Yes, sir, I can hear you.
All I know to do is might be just unplug it from the system and see if we can hear it.
Judge, this is Pulaski. Can you hear us?
It's not your problem, it's my problem. Here, I can't hear. You can hear me. I can't hear it. I can hear him. but-
We can hear things now. Yeah. Can you hear us now?
This is Pulaski County. Can you hear
I hear you.
us?
Yeah.
Yeah, we're trying to get
Judge,
Adair.
this is Adair. We hear everybody.
Yeah, let me get, I'm gonna do this one Adair case and I'll be with you, Pulaski, as soon as I finish this one case.
Okay. I've got court going on in my other room. That's right. I want to make sure I'm trying to run two courts.
I'll accommodate you right now, okay? This Commonwealth of Kentucky versus Brandon Jones. What do you have in this case?
Because he's on for final sentencing.
Okay, Mr. Jones, have you done the pre-sentence, have you looked at the pre-sentence investigation report done by probation and parole?
Yes, sir. Yes, sir, I did.
Mr. Jones?
Yeah.
Okay, you read it? Is it substantially? Okay. What is the sentence in this case?
Well, Judge, that's something I want to talk about.
Remove your mask, Gary. I'll let you.
Thank you, Judge. Judge, the offer sheet called for 10 years in indictment 21 CR 33 total. And a total of 10 years and 21 CR 34. We get that with some misdemeanor times, some concurrent felony time, but 10 years in both of them. Recommendation arisen of those two indictments to run concurrent for a total of 10 years. We agreed when he entered this plea that we would recommend or not oppose a surety bond with MCR pending sentencing, that he would remain in his residence at all times and only plead for court, drug testing, or medical emergency. There's a provision in the plea agreement. I do this about every plea agreement, so I was quite familiar with it. That if he violated any condition of bond, or if he committed any criminal offense while awaiting sentencing, or if he failed to appear in a scheduled court date, then I would recommend an increased sentence. In this case, that the two indictments be served consecutively. You may recall that when we showed up back in October for the scheduled sentencing, that he was not at his residence, he was not in court, but he was in the McDonald County Jail in McDonald County, Pineville, Missouri. He showed up by Zoom from the Missouri jail where he had been arrested for stealing catalytic converters October the 14th. So based on his violation of this court's bond conditions, he left his residence and traveled out of state for a new criminal offense. He was unable and did not appear on the sentencing. Because of that conduct while he was on bond, I am asking the court to sentence him to the agreed upon term of 10 years in each indictment. But I would ask if those be served consecutively, consistent with the plea agreement, paragraph 2, third page above the signatures, that those would be served consecutively for a total of 20 years. Consistent with the agreement, of course, I'll take your recommendation.
Okay, you want to move over this way? Take your mask off and then you put it back on.
Your Honor, Mr. Jones did sign this agreement. He understood about the possibility of an increased sentence should he not have any violations of bond pending sentencing. He has not been found guilty of the crime in Missouri. It is still pending, and he maintains his innocence in that crime. We would just ask the court to sentence him to the original agreement of 10 years concurrent. It is a substantial period of time. And while the agreement does allow for an enhancement, it says.
What I'm going to do is, let me ask if it'd be possible for me to sentence him on one of these charges, hold the other charge in abeyance till we find out what happens in Missouri. And then I can determine if I make the additional charge consecutive or concurrent then.
And I can tell you, when he was given an OR bond there on his arrest, he was brought back here. We issued a warrant, we entered that into NCIC. So then in January of this year, they issued a warrant for him because of course he failed to appear for a hearing in Missouri. So there's an outstanding warrant. Once he's sentenced here, it'll be up to them whether they extradite, take him back to Missouri. But so it may be some time, but that's.
And the failure to appear was just because he was housed in jail here, not because he just couldn't go.
And of course, my position would be, even had he not committed a crime, which I have a police officer report circumstances, he left his residence and went to Missouri, not just across town, but outside the state of Kentucky. Court obviously had to get the Commonwealth with great lengths to get him back here from Missouri.
You stipulate the fact then that he was in Missouri.
He appeared in open court from Missouri, Your Honor.
Okay, well, I'll go ahead and sentence Mr. Jones to 20 years and 10 on 10 because he violated the terms and violated the agreement. Thank you very much. Okay, now, do you have anything else in the Adair court?
James Griffiths.
Okay, well, I'm going to Pulaski because they got double duty going on. Commonwealth, Kentucky versus Kevin Stark, 20 CR 0053. Pulaski County.
We're here, Judge.
Thank you.
I think you've got my camera turned off on your end. But we can see you.
It's on now.
Okay, we got it. We got it now.
Okay. Commonwealth versus Kevin Stark, 20 CR 0053. It says a motion for release of records. What is it? What does the Commonwealth have to say on this case?
Your Honor, we would like to get the medical records when he was shot. That would be agreeable.
When he was what?
I think he was in a shooting situation. He got shot, and the Commonwealth would like to see the medical records.
And why is that? Who represents Mr. Stark?
Your Honor, I'm not sure. Yeah, wait a minute. Mr. Noel Caldwell, Lexington. Kentucky.
Where are they at?
Lexington, Kentucky.
I know, but they're not here. They're not on the line. Were they given? Megan, have we heard from these attorneys?
No, I've had no contact.
We can't hear you. You need to come up.
He sent.
They were going to negotiate on Monday on maybe a settlement on this case. They just called in yesterday. I was not aware they were on the
Okay, well, I will pass this till March the 31st. Thank you very much, Pulaski County. We're sorry we inconvenienced you, okay?
That's all right, Judge. Appreciate you getting quick.
Thank
Are
you.
we still on trial March 15th?
Well, what they said is your attorney, you are scheduled, but your attorneys called in and said they were going to continue their negotiation on Monday. So, you know, that I don't know what, I don't want you to talk about the negotiations on the record or anything, but I'm sure they'll be in contact with you. You need to try to contact them today. Okay. I'm not going to hold it again. They were in contact with Commonwealth Attorney's office. Commonwealth Attorney himself is out of town today, and someone from his office just got on the record and said that they have no problem with passing this. I guess we won't pass it to 31st because you're scheduled for a trial. Your attorneys will get with the court on Monday or Tuesday of next week to see if the trial goes or where they've got a successful negotiation. Okay.
Okay.
Okay. Thank you very much.
Thank you, Judge.
Yeah. Let's go ahead and do these where we just have one person. In Russell County, are you on there? Is Russell County on? Taylor County, are you on?
Yes.
Taylor County, will you come on, please?
Yes, sir.
And then I'll get to Casey County immediately after that. Commonwealth of Kentucky versus Aaliyah Hurt, 21 CR 00124. Mr. Johnny Bell represents Ms. Hurt. I don't see him here today.
I'm present, Your Honor. We contacted Megan and she allowed.
Turn your camera on then. Maybe I can have Bobby Richardson come over and help you turn the camera on.
He'd help me, Judge.
Yeah, I know. We've had quite a trouble with him on the camera though. This is a pretrial conference. What's the Commonwealth had to say?
I guess we're waiting to hear back from Mr. Bell.
Judge, if I may, I can tell you where we're at or where I'm at, and then you can tell us where we're actually at. I have talked to Mr. Stockton, Your Honor, and I've talked to my client several times. I've been over the discovery. We've been in negotiations, and I would like an opportunity to talk to Mr. Stockton one more time about some concerns that my client brought up.
Is there a trial date? Is there a trial date scheduled?
Not yet, Judge.
Okay, you can negotiate if it on the 11th, March the 11th.
Yes, sir.
The case will next appear on March 31st.
Thank you, Judge.
Okay, thank you, Taylor County, for your cooperation.
Yes, sir. Thank you. Have a good day.
You too. Casey County.
Yes, Your Honor.
We have Savannah Branham there, I believe. Commonwealth versus Savannah Branham, 21 CR 00139 and 22 CR 0001. You Savannah Branham?
Yes, sir.
And what's your year of birth?
6893.
Last four digits of social security number.
6915.
Okay, what do we have here? Have a plea?
Yes, Your Honor.
Is it a
plea, Your Honor?
Okay. Ma'am, a motion's been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
You're the same person in indictments number 21 CR 00139 and 22 CR 0001. Is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these matters with your attorney and are you satisfied with her advice?
Yes.
Have you viewed the evidence the Commonwealth has against you and you believe you've been fully informed about the case?
Yes, sir.
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. As you understand, by entering a guilty plea today, you give up those rights. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Judd, what is the Commonwealth's recommendation?
Your Honor, please, the Commonwealth agrees to dismiss 21 CR 00139, charges reckless driving and operating a motor vehicle on one headlight, resisting felony offender in the first degree, and also dismiss in the case of 22 CR 0001, possession of controlled substance first degree and possession of drug paraphernalia. And then upon plea of receiving stolen property over 10,000 in case number CR 00139, the defendant shall receive 5 years to serve. Upon a plea of guilty to fleeing or evading police first degree 2 counts in case CR 21 CR 00139, the defendant shall receive a sentence of 5 years on each charge run concurrently for a total of 5 years to serve. Upon a plea of guilty of wanton endangerment first degree in case 21 CR 00139, the defendant shall receive a sentence of 5 years to serve. Upon a plea of guilty to failure to maintain insurance in case 21 CR 00139, the defendant shall pay a fine of $500. The 5-year sentence in case 21 CR 00139 are to run concurrently for a total of 5 years to serve. And the Commonwealth will impose probation. The 5-year sentence in case number 21 CR 00139 is to run consecutively with the Cumberland Circuit Court case CR 0060 and 20 CR 0061 and 20 CR 0062. The defendant pay fine and court costs discretion of court. The defendant shall obtain gainful employment or do 30 hours per week community service. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with state law.
There wasn't a DUI in there at all. There was no DUI.
No,
Charge, okay.
Okay.
Ma'am,
No,
are you pleading guilty because you are guilty?
Yes,
And you agree with what the Commonwealth's recommendation was? That's what you agreed to?
yes,
Okay. And knowing your constitutional rights, so I explained it to you, is it still your desire to give up those rights, enter a plea to the charges and allow the court to fix the punishment when the range permitted by law? You understand by entering a guilty plea, any future convictions could be enhanced under persistent felony offender law. Do you understand that?
yes, sir.
Now, do you have this? You have the document?
I do, Your Honor.
Ma'am, is that your signature on there?
Yes, sir.
Okay. I will accept the plea. Order pre-sentence investigation report done.
Your Honor, if I may, she's the state inmate, she was sentenced by this court, I think. And she's willing to waive her final.
Would you waive the pre-sentence investigation report and allow the court to enter a judgment today? Well, we'll do
Yes,
that.
sir.
We'll do that. I hope things turn around for you. Okay?
Thank you.
Good luck. Casey County, that excuses you. Thank you for cooperation today.
Thank you, Your Honor.
Now, did we have Russell? Did we finish Russell County? Russell County, are you on there?
Never joined.
Okay, then we'll go, I guess we're ready for the Adair, to go to Adair County to start the Cumberland County incarcerated. Yes. Yeah, you can't do this at the podium. You're gonna have to set up a computer back
I started the process, Your Honor. If I have just a couple minutes.
there. Okay. Some courtrooms are set up to do that, others aren't.
Right, and if this was work, it would.
Are we ready?
Judge, this is Adair County. We're here and ready, but Russell County just came on. If you'd like us to stand by, sir, we will.
Okay, that'd be good. The public defender can't get hooked up here on the computers, what we're waiting for. I guess we'll thank you for telling me that, and we'll do Russell County right now. Could you check and see how that's going back there for her? Commonwealth Kentucky versus Casey White, 19 CR 0039. Are you Casey White? Is your microphone on there? Okay. Okay, that'll be. You're Casey White?
Cassie White, yes.
Cassie, okay. Your attorney's getting online there. You're here today for the purpose of sentencing. Have you had an opportunity to read the pre-sentence investigation report done by probation and parole?
I did.
Is it substantially correct?
Yes.
Okay, your pretrial diversion was voided on January 27th of this year. The pre-sentence investigation report was done. On plea of guilty to possession of controlled substance, you shall receive a sentence of 3 years. You shall receive credit for time served. What was the court cost originally? You still owe $230 in court costs. I'll let you start paying that at $30 a month, 30 days after you get out, okay? Okay, thank you very much. Is there anything else for us to do in Russell County now? Is that it?
I believe that's it, Your Honor.
Y'all have a wonderful day and you're
You
excused.
too. Thank you.
Go back to Adair County now. Louis Arms. Okay, Commonwealth versus Louis Arms, 21 CR 0058, 21 CR 00159, 21 CR 00137. What does the Commonwealth have to say about this case?
Your Honor, I believe he was considered for drug court today.
He was accepted into drug court today, Your Honor, and we have a plea agreement.
Okay. Is it a felony plea agreement?
It is, Your Honor.
A motion was tendered, Mr. Arms, that says you wish to enter guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictments number 21 CR 0058, 159, and 137?
Yes, sir.
We had plenty of time to,
Yes, sir.
to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed all the evidence the Commonwealth has against you, and you feel like you're fully informed about your case?
Yes, sir.
Okay. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand by entering this guilty plea today, you give up those rights, and I may consider the Commonwealth's recommendation, but I may apply a range of sentences by the law. I do not have to accept any recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, what is the Commonwealth's recommendation? Listen very closely, Mr. Arnold.
Your Honor, he's been charged with 3 crimes, and the Commonwealth agrees to dismiss 21 CR 00058, possession of drug paraphernalia and no operator's moped license, and in 21 CR 00159 to dismiss convicted felon in possession of a firearm. Upon a plea of guilty to burglary in the 3rd degree in case 21 CR 00137, the defendant shall receive a sentence of 4 years. Upon a plea of guilty in case 21 CR 00058, the defendant shall receive a sentence of 3 years. The 4-year sentence in case 21 CR 00137 is to run consecutively with 3-year sentence in case number 21 CR 0058 for a total of 7 years, probated for 5 years. Probation is to be supervised. The defendant shall be released at final sentencing or orientation with drug court. The defendant shall receive credit for time served. The defendant shall enter and complete the Cumberland County Drug Court. The defendant shall pay court costs at discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week community service.
What's the court cost? I'm gonna combine the court costs in the 3 cases. Okay, I'm gonna combine the court costs in the 3 cases. It'll be $350. And Mr. Arm can start paying that at $30 a month after 30 days after he gets into drug court. So that'll give him some time to get out, get something going on. I will accept the plea, order pre-sentence investigation report done by probation and parole. Have him back here on March 31st for sentencing. Now, he can't start drug court till after the sentencing. Is that correct? Is that part of the agreement?
Your Honor, I think he could go ahead and start since he was accepted today. I think he could start at orientation, which may be next week sometime if the court allows it.
I don't think. Well, there has to be an order, but I don't think he can do either one of them until after he's sentenced.
The order was signed last month, Your Honor. I don't know.
He hadn't been sentenced. He can't do it till after he's been sentenced. That's what I'm telling you. Now, if you can inform me to the contrary, because I haven't made my decision on whether I'm going to accept the plea or not. So how could he go ahead?
True.
So, I think that's what the deal. We just need to have him ready on the 31st to do the orientation, get him out there as quickly as possible. Okay. Okay. Well, thank you very much, Mr. Arms. I tell you, I've known you, I guess, as long as I've known anybody. And every time I see you when you've been in jail for a while, you look healthy and your mind is clear and everything. I hope this time when you go through the drug court, you and I both are getting a little old to continue meeting like this, aren't we? You know, I hope you get straightened out. Yeah. I hope you have a success with that. Okay, thank you very much. Douglas Bowe. Douglas Bowe.
Let's vote, Judge.
Commonwealth versus Douglas Bowe, 22 CR 0010. You're here for the purpose of arraignment. Do you have an attorney, Mr. Bowe?
No. I had Mr. Costello in the small court.
Okay, well, I'll continue that. I won't tell Judge Costello that you called it the small court in case you ever go back down there at district court, you know. I'm gonna continue the appointment. You're here for the purpose of arraignment. The grand jury of Cumberland County has charged you with assault in the 3rd degree, tampering with physical evidence, assault in the 4th degree, terroristic threatening, resisting arrest, possession of marijuana, criminal mischief, disorderly conduct, alcoholic beverage in a public place, and being a persistent felon offender. You understand those charges?
Yes, sir.
Okay, Ms. Costello, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, Mr. Bowe, you'll be present for negotiations on March 11th, and the next court date will be on March 31st, okay?
Okay.
Thank you very much.
Your Honor, has there been a bond set for him?
Let me see what the bond is.
Currently 10,000 cash, I believe, Your Honor.
Okay, that'll be fine. Huh?
Paul,
It's actually a $25,000 surety bond.
25 sure,
Yeah,
with a curfew on it.
yeah, the standard.
Paul Bricker. Paul Bricker. Are you Paul Bricker?
Yes, sir.
Okay, this is 21 CR 00148. Mr. Cross is present. Mr. Cross, you want to go back to that there and share the public defender? Okay, Mr. Brigger, you see your attorney, Mr. Cross there now, correct? We're here for a conference. What does the Commonwealth have to say about this case?
Your Honor, we'd like to set this up for the negotiation on the 11th.
Mr. Judge, will you scoot over to your right a little bit?
I'm sorry.
There you go.
We'd like to set it up for negotiation on March.
That's agreeable, Your Honor.
Okay, March 11th for negotiation. Next court days on March 31st.
Thank you, Your Honor.
Taylor Chambers.
There's a plea.
Combo versus Taylor Chambers, 21 CR 00142. Are you Taylor Chambers?
Yes, sir.
Okay.
Your Honor, I have the paperwork for the court that's receiving, it's got everybody's signatures on it, Your Honor.
Okay, is this a felony plea?
It is a diversion plea, Your Honor.
Okay. Ms. Chambers, I understand that you wish to enter a plea today. Is that correct? Okay, that's okay.
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment 21 CR 00142 in the Cumberland Circuit Court?
Yes, sir.
Have you had plenty of time to review this matter with your attorney? You feel like you're fully advised about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to read down through them. You can answer at the end of when I read them all. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to part of the Commonwealth, prove on a reasonable doubt that you are guilty of the charges against you. You understand that by entering a plea of guilty, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Have you previously been on a pretrial diversion in the last 5 years?
No, Your Honor.
Have you had any felonies in the past 10 years?
No, Your Honor.
Are you presently on probation or pretrial diversion?
No, sir.
You understand if you successfully complete the diversion program, the case will be dismissed, pretrial diverted. You understand if you do not complete it successfully, you'll be brought back in court and the court will schedule a sentencing hearing. And at that time, you'll be sentenced to be a convicted felon, can be used against you in the future. Listen very carefully to what Mr. Judd has to say to see if this is a recommendation of the Commonwealth. Mr. Judd.
The Commonwealth agrees to amend theft, unlawful taking, or disposition pursuant to KRS 514030, Class C felony to theft, unlawful taking under 10,000. Upon a plea of guilty to theft, unlawful taking under 10,000, the defendant shall receive a sentence of 5 years pretrial diverted for 5 years supervised. The defendant shall enter and complete the Cumberland Specialty Program. The defendant shall receive credit for time served and shall be released from incarceration the morning of Cumberland Specialty Program orientation. The defendant shall pay court costs at discretion of the court. The defendant shall obtain gainful employment to a minimum of 30 hours per week community service. The defendant agrees to have any and all evidence disposed of in accordance with the laws of the Commonwealth and the holding agency.
Ms. Chambers, is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you are guilty of the acts committed in the indictment as amended?
Yes.
Okay, knowing your constitutional rights, I've explained it to you. Is it still your desire to give up those rights, enter a plea of guilty to the charges and allow the court to fix your punishment within the range permitted by law?
Yes, sir.
Okay. Do what? Is that your signature on there, ma'am?
Yes, sir.
Okay, I'll accept the plea. The court cost, is there a DUI? Why 635? 235. Your court costs are $235. I'll allow you to pay that $30 a month, starting 30 days from today, or 30 days, starting 30 days from your entry into the drug court. I'll wait to get out, get started there. You'll need, the probation parole officer will need to speak to you. Pardon? You'll be up there, or?
I'll be in Columbia.
She's not going to get out tomorrow, though. Is she getting out?
Our agreement was, Your Honor, that she would be upon her orientation to drug court.
So she'll still be in court up there. She'll still be in jail. The probation parole officer will be to see Ms. Chambers tomorrow to get that information, so it won't delay anything, okay?
Thank you, Your Honor.
Thank you. Claude Cole. Claude Cole is the next case.
Claude Cole, Judge.
Commonwealth versus Claude Cole, 22 CR 00009. Are you Claude Cole?
Yes, sir, I am.
What's your year of birth, Mr. Cole?
1968,
Okay, and the last four digits of your social security number.
6795.
Okay, you're here for the purpose of arraignment. You have the right to remain silent. Do you have an attorney or are you represented by the Office of Public Advocacy?
I had a public defender.
Okay, here she is. Ms. Costello is on there. Ms. Costello, the grand jury of Cumberland County indicted Mr. Cole with possession of a controlled substance, first degree, possession of marijuana, possession of drug paraphernalia, operating motor vehicle under the influence, operating motor vehicle with expired driver's license not in possession, failure to notify address change Department of Transportation, possession of open alcoholic beverage, careless driving, disregarding stop sign, and inadequate muffler. You understand those charges, sir? You understand what the charges are?
Yes, sir, I do.
Ms. Costello, do you acknowledge the identity of your client? Receipt. I'm sending the indictment back to you. Waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Ms. Costello. Okay. I'm signing a reciprocal discovery order, sir, that the Commonwealth will give your attorney all the information they have to help you prepare your defense. You will appear on March the 11th for negotiations and March the 31st for your next court appearance. Okay, Keisha Crawford.
Your Honor, would the court consider a reduced surety bond in Mr. Cole's case? He's been unable to post that and he has been incarcerated since district court at this time.
When was district court?
Your Honor, he had his preliminary hearing in November, I believe.
Okay, what is his bond now?
It's a $20,000 surety bond. He posted a surety bond in district court.
Oh, I don't think he was ever released though.
It shows that he posted a $1,000 surety bond on 12/22/21.
Who signed it?
Betty Jo Ray.
And the
$1,000.
Your Honor, Mr. Cole's been back 2 weeks, Your Honor.
I apologize. So he was released then.
Okay. Well, I'll do a $5,000 surety bond with the same conditions as far as.
Your Honor, the Commonwealth would like to recommend that his driving privileges be suspended if he gets a bond. It's lowered.
Well, I'll do that, and I'll do a bond and do a curfew on him. You're not to leave the house, sir, unless you're going to the doctor or church or work. Okay, I'll go ahead and let somebody $5,000 surety bond's not very much. About anybody can sign one of those. You get somebody to go in. Okay.
Thank you, Your Honor.
March 11th to the March the 31st. March 11th here at the courthouse for negotiations. The 31st for the next hearing date. Keisha Crawford.
Your Honor, we are waiting on paperwork from the jail. We will have an agreement on her. I was delayed sending it over.
Dale Cross. That'd be good if you could go back there so your attorney can see. Commonwealth.
Dale Cross, Judge.
Yeah, okay. Commonwealth versus Dale Cross, 21 CR 00158, represented by Mr. Poindexter. Mr. Cross has identified himself. Mr. Cross, what is your year of birth, sir? Your year of birth.
6/12/1958, sir.
Okay, and the last four digits of your social.
6/12/1958.
Okay. What do you have here, Mr. Judd?
7749.
Okay, thank you.
Your Honor, we have a plea agreement.
Is it a pretrial diversion or a felony?
It's a felony.
Okay. A motion has been tendered, Mr. Cross, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Okay, you the same person named in indictment number 21 CR 00158. Have you had plenty of time to discuss this matter with your attorney and are you satisfied with his advice? Mr. Cross, yeah, have you had plenty of time to review the evidence that the Commonwealth has against you?
Yes, sir.
You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may also apply any range of sentence allowed by law. I do not have to accept any recommendation. Prior to accepting the recommendation, I shall await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. In other words, I cannot give you any more than what you've agreed to without you having a right to withdraw your plea. You understand that?
Yes, sir.
Mr. Bell, will you turn your camera off there? It's a beautiful portrait behind you, but thank you. Now, Mr. Judd, will you go over the Commonwealth's recommendation?
The Commonwealth agrees to dismiss wanton endangerment of the first degree, terroristic threatening the third degree, and public intoxication. Upon a plea of guilty to wanton endangerment to first degree, one count, the defendant shall receive a sentence of 5 years probated for 5 years. Probation is to be supervised. The defendant shall receive credit for time served. The defendant shall be released at final sentencing. The defendant agrees to be assessed and follow any recommendations by the Social Service Commission. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do a minimum of 30 hours community service until gainful employment is obtained. That's it, Your Honor. Thank you.
Is that what you agreed to, Mr. Cross?
Yes, sir. Yes, sir.
Okay. Knowing your constitutional rights, is it still your desire to give up those rights and allow the court to fix your sentence as permitted by law?
Your Honor, we do need to clarify one thing. He draws disability, so he's not able to work.
That'd be fine. Just,
okay.
Just file notice of his disability and I will not put a work requirement on there, okay?
Okay, thank you.
Do you understand that by entering this plea today, any future convictions of felonies could be enhanced under persistent felony offender law? You understand that? Okay.
Yes, sir.
Will you hold a signature up there, Mr. Poindexter document? Is that your signature there, sir?
Yes, Your Honor.
Okay, I will accept the plea order, pre-sentence investigation report done by probation and parole. Your report here on the 31st for sentencing. And if everything is in order, you'll be released on that day, okay? Okay, thank you very much.
Thank you, Your Honor.
Buddy Dyer. Commonwealth of Kentucky versus Buddy Dyer, 19 CR 00090, 21 CR 00135 for a pretrial conference. You are Buddy Dyer.
Yes, sir.
And what's your year of birth?
January 6, 1987,
The last four digits of your social security number.
6887.
Okay, we're here on a revocation and a pretrial conference. What does the Commonwealth have to say?
Your Honor, there's a motion to revoke probation and grounds for the revocation. There is a list which includes the defendant's failure to pay restitution.
Your Honor, if I may, I've spoken to Mr. Stockton about this. Mr. Dyer was never on probation on that case. He was a state inmate and served that out.
Well, we'll check into that. We still have the new charge, correct?
Yes, yes, Your Honor. And today, Mr. Dyer was voted eligible and accepted into drug court, which I think will affect our offer in this. So I was going to see if we could reset this till March the 11th.
Okay, we'll set it for negotiation on the 11th, and then we'll next appearance will be March 31st, with pushing the date as quickly as we can, Mr. Dyer, to get you into drug court. If you agreed to that, are you going to agree to a drug court situation?
Yes, sir.
So I'll sign the referral, and then we'll I guess the plea will be on the 31st, unless he could plead sooner than that and be ready for sentencing on the 31st. But if y'all can work that out, I'll agree to be amenable to that. But if not, we'll be on the 31st. Okay.
Okay.
Thank you. Okay. I need to go down to wait on the grand jury just for a second. And so we'll take a brief pause here for me to go down there and do the grand jury. I'll be right back up and finish the Area Circuit Court. You can move here and turn this off just a second to make sure that. What's that?
Good night.
Not working. Megan, can you hear me? Megan, can you hear me now?
Just come up when they come.
Yes.
Okay.
You trying to get, can you hear me? That's okay. Okay, try it now. Okay, try it again. Okay. Okay, I'm just. Okay, try it now. Okay, try it one time. No. I'll leave it. Worked on one of them. Try it. It's homework. Like you.
I'm about to die. The team scored question out here right now. What's on my face? No.
Run one over pitch your car. Oh my gosh. That's weird.
It's.
Right here, that's cool.
But I am.
Yes, yes. All you gotta do is twist it.
Oh, my fault.
Can you hear me?
Well, you were both, it's because of you.
Oh, it's my fault.
No, it's not their fault, right?
Oh, yeah.
All right.
Get your water thing. I'm trying to get it.
Okay, try it again, like.
I'll explain that to him and tell him that that's something he needs to do.
Well, per policy, I have to have a current drug test before I can recommend it to the judge. If he can't pass it, then it's up to judge.
I told him I was gonna kill him myself. He could pass the drug test. He should have been meeting with him when they got. He said he was in his pockets full of copper wire.
I can't, he had to have at least 10 pounds of copper in his pockets. He was wearing like overalls, he was pulling copper out of every pocket. That was one to me, and he looked like a Christmas tree.
Okay, let's come back to order. Come back to order, please. Adair County. Adair County Jail. Mr.
CR
20 CR what?
20 CR 139
Okay.
and 20 CR 127. This is an agreement that resolves both cases, Judge.
Okay. Is this a felony plea?
It is, John.
Are you James Griffin? Let him in the center behind the thing there. You stand to his left. Are you James Griffin?
Yes, sir.
Mr. Griffin, what's your year of birth
1986,
and the last four digits of your social security number?
9166.
A motion's been tendered today that says you wish to enter a plea in two cases that I called. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily entered?
Yes, sir.
You're the same person named in 20 CR 000135 and 20 CR 000127?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
I am.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about the case?
Yes, sir.
You realize you do not have to enter a guilty plea today. No one can make you say anything. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have the right not to testify against yourself, the right to speed trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court. You have a right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charge against you. Understand? But in your guilty plea today, you give up all those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting recommendation, I will await pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. If you'll stand to the left there, you understand all those things I just read?
Yes, sir.
Okay, Counselor, if you'll stand to the left also. What's the Commonwealth's recommendation?
Says let me refer back to this written offer, so I'll make sure. Judge, in the older case, 127, it'll be a total sentence of 2.5 years. That'd be consecutive to 20 CR 139, which is a sentence of 5 years. So a total sentence between the two cases of 7 years and 6 months. We recommend probation for 5 years, assuming that everything's complied with pending sentencing. And then there would be an agreement, of course, to a forfeiture of everything that was seized, which included contraband, small amount of cash, and some, $521, drugs, and some paraphernalia.
Okay, you want to come back over here, sir? Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Has anyone, including your attorney, offered you another consideration, or are you pleading guilty because you are guilty?
Yes, sir.
Knowing constitutional rights I've explained to you, is it still your desire to give up those rights, by entering guilty plea to charges, allow the Commonwealth and the court to fix your punishment within the range of sentence provided by law? But you understand, by entering this guilty plea, any future convictions of felonies could be used against you in a persistent felony offender law.
Yes, sir.
Okay, do you have the plea document there in front of you? Is that your signature on there, sir?
Yes, sir, it is.
Yeah. Okay, I'll accept the agreement order pre-sentence investigation board and have you present here on March 31st for sentencing.
March 31st, Judge.
March 31st for sentencing. And you want to take these papers back up with you?
I'm not sure.
Yeah. That'd be good. Now, if y'all want to come down here on that date, if the report doesn't find anything terrible, I'll allow y'all to appear by Zoom for sentencing, since it's a probated sentence, okay? You want to drive in, although it's always good when you hit it downhill, it's a drive back up there.
What time would that be, Judge, on the 31st?
We can do you, but y'all can just send us a time, what times. You're on that fast time up there, so
Fast time.
we'll start at 9. You can do it at 10 if you want to.
10 Central Time.
Yeah, we always go by our time here, wherever I'm at. If I'm in Honolulu or Hawaii, I go for the same wherever I'm at, you know. That our time or your time thing would do nothing to get you messed up, you know, prevailing time, this is the thing. Okay, the court costs on that thing. We don't know. Would you find out what the court cost is up there and tell us? They're a little different in every county. And I'll put the court costs. And then when it comes time to sentence, and if you need some time on the court costs, I'll allow you some time. Okay. Okay. Thank you very much.
Thank you, Your Honor.
Yeah. Okay, thank you. Okay, let's go back to Adair County. Randy Franklin. 21 CR 00119. Mr. Bell. I saw you.
Yes, Your Honor. Yes, sir.
Okay, we're here on Brandy Franklin, 21 CR 00119. What's the story?
Yes, sir.
Mr. Judd? Need to turn your microphone on, Mr. Judd.
Your Honor, we have a motion to revoke.
Okay, what's happened here?
Can you hear me?
Yeah, I can hear you. What's happened to you?
Okay, what's happened, he's failed to attend substance treatment at least 3 times. And also, he did not tell the truth about getting permission to do something.
What do you have to say about that, Mr. Bell?
Your Honor, Ms. Franklin, she did not go to treatment. It's my understanding from probation and parole. I only got to talk to him one time. I think he was upset with me also, which is okay, but he advised that he had set Ms. Franklin up to go to treatment 2 or 3 times. She was calling the office wanting to know if we would have been able to put her into a treatment. When I left court that day, I thought that was understanding, but long story short, Judge, she didn't go to treatment. We weren't able to communicate a whole lot with her, but in her defense, Judge, you know, Miss Franklin is an addict. That's what she's here for. You know, and I know that I strongly advocated for her to be let out on a bond, which that's on me. That's my fault because she had her children and stuff. And I would ask the court, due to the fact that she really didn't even have an opportunity to get clean and get away from the individuals and go to treatment, I would ask the court to consider not revoking Miss Franklin and setting up a situation where she'd go straight from jail to treatment to hopefully.
You stipulate to the violations, is that correct?
Yes, sir, I do.
Okay. What's the Commonwealth have to say?
Your Honor, I just leave it up to the court's discretion.
Well, I'm gonna have to revoke Ms. Franklin. She got, as far as I'm concerned, special opportunities given to the court. She got out, she had opportunities to go at the situation. And I don't think that she's gonna be able to overcome this hurdle that she has to, as far as getting this addiction off her back without being incarcerated somewhere where she can get treatment and can't leave when she wants to. So I'm gonna revoke her and impose the sentence. Okay, thank you very much. Raymond Garrett. Raymond Garrett. Commonwealth versus Raymond Garrett, 18 CR 0052. Are you Raymond Garrett? Okay, we're here for sentencing. Office of Public Advocacy represents you. Ms. Costello, you want to turn your microphone on?
Yes, Your Honor.
Okay. Okay. Mr. Garrett, have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct?
Yes, sir.
Quit.
Well, you're still on there. Is that your evil twin
I
back
think
there?
maybe, I don't know, I think my computer, it shut down and turned blue and then shut down and made a noise, and now I'm on the screen and in person. I don't know.
It kicked in. This, and whatever you did, thank you. She's probably the problem. But okay, has your client looked at pre-sentence investigation report number probation parole? Is it
Yes, Your Honor.
substantially correct?
I believe so. I didn't see any correction.
What does the Commonwealth have to say about this case?
Your Honor, I don't have any information except just to go ahead with the sentence.
Well, I got some information here. I guess the last rule day we had here was the 27th of January. And I let this gentleman out of jail on the 27th of January. And the Columbia Police Department arrested him on the 28th, charged him with substance abuse.
It was the same day, Your Honor.
Same day, yeah. Alcohol, possession, first degree, unresponsive male. This concerns me. Says it was, he said he was asked what was in the heroin, in the needle, and he said it was heroin. And he was an out-of-state person, which I made a special exception on letting him out. And I let him out and he almost dies of a heroin overdose up there. So what does the Commonwealth have to say about that? Where's it?
Your Honor, that case would be in the Darius Circuit. Is that correct? Yeah. I would go ahead with the sentence.
Well, I'm not going to probate him, is what I'm telling you.
Okay.
I'm not going to probate him. I mean, I let him out of jail.
Yeah, I understand that.
And he's got it. So I'll give him 5 years if he wants it, or he can withdraw his plea, either one he wants to do.
Your Honor, if the court's not going to accept, would the court allow us to reset until next month to determine that and discuss it?
But I'm pretty plain.
I understand, but
I
to see if
don't
he
know what
would
there is
wish.
to discuss, really. If you want to go have a sidebar, I mean, you can set up a sidebar with him back there and talk to him online. We can set up a chat, a room, whatever they call it. You can talk to him.
Okay.
We'll bring the case back up. Yes.
She's not on Zoom, so I can't.
Hey, she can't do that. You can call him on the phone up there at the jail. Contessa Gore.
Judge, also, going back to Miss Brandy Franklin's case, you revoked her. That was a pretrial diversion, so she'll need a PSI.
Okay, well, I do a pre-sentence investigation report and have her back here for sentencing. Leave her in jail. And have the sentencing on March 31st. Commonwealth versus Contessa Gore, 21 CR 003, 20 CR 0048, and 20 CR 0052. This is Matthew D. Hart's case.
Response to this motion yesterday, respectfully saying he has not had any contact with her since she was sentenced.
Was this a private case? Did you have him as a private attorney? Score, was he a?
Yeah.
He did. He filed a notice here that says that since the completion of sentencing, his duties were fulfilled for which he'd been retained, and he's had no contact with you since then. So. Are you going to be able to get another attorney or?
Yeah, if we could just continue this.
Well, I'll continue to March the 31st. Are you able to hire an additional attorney? Have money to hire an attorney? Or do you want public advocacy appointed?
I think my grandpa's going to do it for me.
Well, did Mr. D. Hart contact you and tell you he wasn't going to be here today?
I haven't heard from him at all.
Okay, I'm gonna order a show cause for him to appear on the 31st to explain why he didn't appear here today. He's still attorney of record, or why he didn't contact you or withdraw from the case in an appropriate time period. You be back here with an attorney on March the 31st, okay?
All right.
Thank you. Bradley Gunter. Issued show cause why he should not be held in contempt of court. Bradley Gunter is the next case. Are you Bradley Gunter?
Yes, sir.
This is 21 CR 00152. You're here today for sentencing. You're represented by the Office of Public Advocacy. I guess this is Ms. Costello's case.
Yes, sir.
Do what? Tell her to come on in here. It's working in here now. She gets back online, it might knock the system out again. I don't know.
Oh, okay.
Kind of like Green Acres. You plug two in, it turns it off. You got to plug one out. Bad when I say something and nobody in the courtroom remembers Green Acres. It kind of tells you something about yourself. That was on right after Arthur Godfrey, Mr. Poindexter.
I don't know Arthur Godfrey, but I remember Green Acres.
Oh, good. It makes me feel better.
Green Acres is fantastic show. I used to watch it all the time.
There's something about you that you like that, but that's
Oh.
okay. Bradley Gunter is here, 21 CR 00152. Are you Bradley Gunter? Mr. Gunter, have you looked at the pre-sentence investigation report done by probation and parole? Can you see that?
Yes, I've looked at it.
Okay, is it substantially correct?
Yes.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty to traffic and controlled substance, 2 grams of meth, the defendant shall receive a sentence of 6 years, serve 6 months, balance probated for 5 years, probation to be supervised. He agrees to forfeit $2,168 to various entities. What's the court cost in this case? Court cost is $185. You need some time to pay that. I'll let you pay the first $30, 30 days after your release, and $30 a month till you pay that. Does he have his time in?
Your Honor, he has 114 days in of his 180 days. He has lined up employment if the court would consider reducing the amount of time.
I can't reduce it right now, but I thought he might have, he's got how many days in?
114 of it.
Well, he's got a good part of it killed. He's got
He does.
3 months. Okay. Okay, thank you very much.
Your Honor. Your Honor.
Yes.
I'm sorry. I heard what you said. My mother is in a really bad place right now. She's in first stages of kidney failure, and they're trying to evict her from her house. And I mean, she doesn't have anybody out there to move her stuff or help her in any way. It's really hard for her to get around right now. I mean, is there any way you can reconsider?
You need to leave in order to go help her move. Is that what you're telling me?
Yeah, she can't even hardly get around. And I mean, my vehicles are stuck in the driveway and she's not got no way to move them. She's gonna end up losing a lot because she's not even gonna be able to pack her stuff.
What's the Commonwealth have to say?
Hunter, we don't object to a leave under those conditions.
How many days does he have in now? 100 and what?
114, according to the PSI.
Well, Mr. Gunner, they say no good deed goes unpunished. I'm going to allow you to serve this 115 days instead of the 6 months. But I'm going to tell you something. I let a guy out a few minutes ago. You probably heard that. Next day he almost died. I don't know you. I've read the sentence report. Doesn't seem like you've been in a whole lot in your life, have you? You know what I mean?
Thank you, Your Honor.
You go move her. And I'll give you 30 days out. And then once you get her set up and everything, you come back and do the rest of your 6 months.
Okay.
If you do all right between now and then, I might consider you might not have to go back at all. So I'm going to set you for a review on April the 28th. Go ahead and sentence him on April the 28th.
Thank you, Your Honor.
Thank you, Your Honor.
Well, I'll review it. I'm sentencing him today, but I'll review it on April the 28th. And I'm going to. That's a condition of the sentence. And if he stays straight in 30 days, something, I'll look at it. But if not, he should turn himself back in here on April 28th. Okay. Now you need to meet with him somewhere.
I do, Your Honor. If you can release in the morning.
I'll release you in the morning. You go straight to probation and parole office there in Columbia. Where does your mother live?
Tennessee.
Where?
Tennessee.
In Tennessee. Jamestown, Tennessee. But I mean, I can have her,
Yeah, I know, but that complicates the thing, because we gotta get you transferred down there. How long will that take to transfer him?
They get a 30-day, well, I can get them down there in 14 days, but it's 14 plus the 30, so. As long as we take him to move is, give him a month, Your Honor.
You want me to delay sentencing for a month? Would that be the best thing to do?
If you did that, Your Honor, then probation parole would be obligated to monitor him. I don't mind monitoring for the month.
Okay, I'm gonna put you. You go to probation and parole in the morning, and we'll monitor you for a month till we get you transferred down to Tennessee.
okay.
Don't spit on the sidewalk, man. You know, I mean, I hope, and I have no reason not to believe you about your mother, but I will tell you that there's a special place in hell for people who would use their mother as an excuse to get out if it's not going on. And I'm believing what you're saying, okay?
Appreciate it.
Do what?
Megan asked if Ms. Costello could do an order on that.
Do an order on that, Ms. Costello. Okay, Dustin Hayes. Dustin Hayes. Commonwealth versus Dustin Hayes, 21 CR 00138. Are you Dustin Hayes? Are you Dustin Hayes?
Yes, sir.
Okay, what's your year of birth?
November 2nd, 1986,
And last four digits of your social security number.
7836.
Now, do we have an arraignment here too? Please. Now, there's an arraignment in 22 CR 005. You have a right to remain silent. Your attorney's present. The grand jury, Cumberland County, charge you with possession of controlled substance of first degree, possession of drug paraphernalia, and careless driving. You understand those charges? You understand those charges? Okay. Now, we have a sentencing here on this other case. Were these two cases resolved by this situation or this other one still?
No, it's still active, Your Honor. On the other case, he was referred to drug court and was accepted this morning.
His first version was more than first.
When was this new charge? Is the new charge why his pretrial diversion was?
Part of it, yes. I believe the bulk of it.
Well, what are you going to do about the new charges? What's the Commonwealth going to do about the new charges?
Your Honor, could we continue them to the March 11th? And
Yeah, we'll meet to negotiate those on March the 11th and March 31st. I don't know whether they'll let him in the drug court with pending charges, will they?
They will, since it's a possession charge.
Do what?
They will if it's since it's a possession charge. I don't think they'll have an
Well,
objection.
yeah, it's more than possession charge.
Possession of,
drug paraphernalia, I think.
yeah, which is the misdemeanor. I don't think that will prevent him since it's a misdemeanor. We've had other people that had those charges.
Okay, well, y'all negotiate on the 11th. If there's anything else that needs to be done, we'll do it on the 31st.
Your Honor, he was going to be oriented next week. Would the court allow him to be released for drug court orientation?
I'm sentencing on this one. It's 3 years. And then I guess we'll probate him. Is that right, Mr. Judge?
I think it is, Your Honor, but we'll.
I just don't feel comfortable with all this stuff right now, the way it's going on. I'm going to put off sentencing in this case to the 31st and take a look at these new charges.
I understand, Your Honor.
Okay. Kind of gommed up a little bit here. Okay. Y'all meet on the 11th, negotiate the whole thing, and then we'll be back here on the 31st. Christian Jones. Christian Jones.
Oh, it's, yeah. It's special.
Commonwealth Attorney versus Christian Jones, 19 CR 0084. It's a revocation.
I represent Mr. Jones.
You're making an entry of DPA previously represented, is that right?
Yes, sir.
Are you Christian Jones?
Yes, sir.
What's the year of your birth, Mr. Jones?
2/11/1975.
And what are the last four digits of your social security number?
1157.
Okay, what do we have here?
Judge, this
If
is
you
the
want to move over behind here, you move.
it's the Commonwealth's motion to revoke. I do need to amend one part of my motion. Apparently, the restitution has been paid because it was due joint and severally with another defendant. So Mr. Jones himself did not pay that, but another defendant has paid it. So I'm asking that he be revoked on the condition that he has failed to pay his fines and his court costs. He was also arrested back on January the 20th of 2022 for probation violation and 2 other bench warrants. And he admitted on January the 17th to using methamphetamine.
You want, okay, we'll move a little this way. Mr. Poindexter, is he going to stipulate?
No, Your Honor, we'd like to have a hearing.
Okay, call the witness. Raise your right hand, please. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
And Judge, just for the record, I also have Officer Katie Burton. She's a witness too because of the signed stipulations.
Ma'am, will you raise your hand? Officer, excuse me. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Mr. Burton.
I do, Your Honor.
Okay, which one of these witnesses you want to call first?
I would call Officer Garner first.
Officer Garner will be called first. He's been sworn.
And if you would you state your name and what position you hold?
Officer Jeremy Garner with probation and parole
And how long have you held that position?
since August of 19.
And as part of your caseload, are you required to monitor Christian G. Jones?
I am.
And if you would you give the court a brief history of what his conditions of probation are in the terms of 19 CR 84 during criminal and circuit court?
The conditions I have are pay court costs $250 at the rate of $50 monthly to the Cumberland County Circuit Court, and pay $1,500 for the victim restitution. At the time, I wasn't aware that that was jointly and separately. And that was on the 19 CR 84 burglary second case that he was probated on.
And when was Mr. Jones sentenced? Was that back on October the 22nd of 2020?
Yes.
And when was he ordered to begin paying his payments for court costs and fines?
Within 30 days of release.
And at the time that I filed this motion, was it your understanding that he had not paid any of those costs or fines?
Yes, ma'am.
Okay. And have you had any issues or problems with Mr. Jones while he's been on supervision with you all since October of 2020?
I have.
All right, if you would go and tell the court about those.
All right. Mr. Jones failed to report to Cumberland County Circuit Court for Rule Day after Mr. Jones was scheduled here for sentencing last month, and then a bench warrant was issued for that. Just after that, on 1/13, he was scheduled to be reporting to me for a regular scheduled report day, where he did not show up for that. And I requested an absconder warrant after going to his residence, and he was no longer there. When speaking with his fiancee, Ms. Portacala, she reported that Mr. Jones had left the state and was residing in Tennessee. However, that cannot be confirmed. And then when I checked with the clerk's office to verify about his monetary debts, that he hadn't paid anything at that time. And this isn't in my report, but the month before that, I did have to go to his house and request him to report because he failed to report that month too. And he was in bed when I got to his house.
Has Mr. Jones contacted your office during any point to advise you that he was leaving the residence of Ms. Portacala?
No, ma'am.
And is that a condition of his probation that he has to maintain a current address with you all and keep you up to date for
It
any
is.
changes?
And then when he did get picked up on that charge, or got picked up on the bench warrant, we went through the jail. I had Miss Burton there to go to the jail because I was not there that day. And she drug tested him and she reported back to me that of the uses.
Judge, that's all that I have of Officer Garner. at this
You want to
moment.
cross-examine Mr.
I do,
Clement?
Your Honor. So, Mr. Garner, you've since learned that the restitution's been paid, correct?
I just moments ago, I can't verify that, I have nothing in front of me, but yes.
Okay. And, okay, so you haven't verified if the court costs have been paid yet or not, right?
I have not.
Okay, all right. And the one day that he failed to report, you went to the home and he was there, correct?
Yes.
Okay. And the other absence that he failed to report, that's when Ms. Portocalis said that he had moved to Tennessee, correct?
Yes.
Just to make sure that I understand the dates, because on that report, it threw me off. Was that January of this year or of last year?
It was this year.
Okay. And the previous time where you went to the house and he was there, was that this year or last year?
That would have been last year. It'd been December of 2021.
Okay. Okay. And so he appeared in this court in January on motion day, right?
Via Zoom.
Okay.
After being picked up.
Okay. And he was, do I understand that he was final sentenced on another case?
Yes.
That day? And that the court in that case probated it?
Yes.
Okay. And so he is technically, he's on probation for that new conviction, and he's just being held for this motion to revoke in this case.
Yes.
Okay. I don't think I have any other questions for him, Your Honor. I'm sorry. Yes, I do. Apologize. Has he ever been offered any type of treatment or ever been assessed by the social service clinician?
I'd have to review my files on that. I don't believe that he has, based off the records I have in my hand at the moment.
Okay, all right. That's all I have, Your Honor.
You want to redirect you to call Ms. Burton?
I'll call Ms. Burton.
Ms. Burton, you're under oath. You respond.
Judge, can I take this down where she can hear me a little bit?
Yeah.
Ms. Burton, if you would you tell us what position you hold and who your employer is?
I work for the Department of Corrections, the Division of Probation and Parole here in the Columbia office.
And as part of your job duties, do you sometimes assist in administering drug tests and meeting with people that are being monitored by probation and parole?
Yes, I do.
And in fact, did you do that with Christian G. Jones back in January of this year?
Yes, I did.
All right, if you would tell the court about that.
Mr. Garner had contacted me that Mr. Jones had been picked up while he was out of the office. So I went and administered a drug test with the help of the Adair County Regional Jail staff, a male. And Mr. Jones was very hesitant at first to admit to the use of methamphetamines. He first admitted to the use of marijuana, that he had smoked it. And when I decided to pull the drug test out, he decided to admit to the use of methamphetamines at that time.
And in fact, did Mr. Jones sign an admissions form for you?
Yes, he did.
Okay. And when did he sign that?
He signed that on January the 21st, 2022.
Okay. And is that also the same form that has been filed here with the court to your knowledge?
It is.
Judge, I don't have any other questions of Ms. Burton.
Mr. Poindexter, you want to come over?
I have no questions for her, Your Honor.
Okay, can Ms. Burton be excused? You excuse Ms. Burton. Thank you for being here today.
Thank you, Your Honor.
Okay, would you like to make your case?
I would ask the court to go ahead and revoke Mr. Jones's probation and sentence him. Judge, obviously, I think he's been offered the opportunity for treatment on multiple occasions. Even when we initially did the plea, he acknowledged he did not have any type of drug issue. Now he's admitted to using methamphetamine. He also has new charges that were similar to the ones that he was sentenced on here in Cumberland County last month. He has the similar charges in this case. And so I don't think that Mr. Jones has been complying with anything with probation parole. He's not been cooperative. And at this point, I would just ask the court to go ahead and impose this 5-year sentence.
Your Honor, Mr. Jones has never been offered any type of drug treatment. He's never had a chance to do inpatient or outpatient. He's never been assessed by a clinician. And I found it interesting that the court had actually probated him last month on a new charge that happened while he was on probation in this case. What he's asking is that he be released today, back on probation, and treat this 30-some days that he's been in jail as a sanction, and that he be assessed by the social services clinician with probation and parole and given the opportunity to receive treatment. That's all.
And Judge, in response, I can't speak to the Cumberland County case. That's Mr. Stockton's case. We're just appointed as a special prosecutor on this one.
And I should tell you, Your Honor, all of his court costs have been paid. I verified that with the clerk this week.
What did we probate him on last month, Mr. Judd?
Your Honor, I don't know.
Judge, I have the plea agreement for that
What
case.
was it on?
He received 5 years, probated for 5 on, it looks like theft by unlawful taking over 500.
When he was already on probation?
Yes.
I don't see how that slipped through, Mr. Judd, do you?
No, I don't.
Your Honor, if I may, I represented Mr. Jones on that case.
So you're how it slipped through then.
Your Honor, Mr. Stockton knew that the case that he was just probated on was different in that it involved wood, cut down trees in the woods next to where he was residing. And that's really what it came down to. And there had been a new homeowner take over the property and things like that. So it was just a little different than most cases.
Well, Mr. Judd, how would you feel about, well, you're not handling this. How would you feel about giving him another 30-day sanction from today and require him to enter into some kind of drug treatment situation? The reason he hadn't been offered drug treatment is because he wouldn't confirm or acknowledge he had a drug problem. And you can't get into treatment if you don't acknowledge it. Now, if you want to talk to him about that, I'll give him a break if he'll acknowledge he has a drug problem. If he doesn't have a drug problem, he's just a non-compliant person and needs to be revoked. So I'll give him an opportunity to get some kind of treatment situation if he acknowledges that.
I think he would agree to it, Your Honor.
Well, why don't you go call him? See if you want to call.
And Judge, just for the record, I had talked to Mr. Poindexter before court. I was open to the idea to him going to a long-term inpatient rehab facility because I think in this situation, that's probably what Mr. Jones needs.
Yeah. Well, y'all talk about it and I'll take him back up at the end of the docket, okay?
Yes, sir.
Jimmy Otterson. Jimmy Otterson.
Judge, this is Eric Bates on Otterson. You had actually issued a show cause for me. I'm in Burkesville. I will be there in a couple of minutes.
Look forward to seeing you. Okay. Jonathan Owens. We'll call you back in a few minutes, Mr. Otterson. Jonathan Owens.
Your Honor, this is a motion.
Commonwealth versus Jonathan Owens, 17 CR 0014 revocation, 20 CR 009 revocation, 21 CR 00155 pretrial conference.
Judge, we mediated this matter. We don't have a resolution. I think we probably just need a trial day. If the court recalls, he stipulated to picking up a new charge at a previous hearing. And we asked the court to hold in abeyance the revocation until disposition of the new charge. And so
what is the new charge? What is 21 CR?
It was a DUI. We've mediated this matter and his parole eligibility is such that it doesn't leave him a lot of good options.
What did it involve alcohol?
Yes, yes.
I want to hear some evidence on the revocation. You want to raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, Your Honor.
State your name and your employment and what capacity.
Officer Jeremy Garner, Department of Corrections, Division of Probation and Parole.
Mr. Garner, as part of your duties, did you supervise Mr. Jonathan Owens?
I did.
And you have his records?
I do.
And would you tell the court about how he's violated the terms of that, of his records? Tell him what he was supposed to do and what he did not do, please.
All right. He received a new felony arrest on 11/8, and the charge was a DUI. I believe this is his 4th or 5th. And then during the report, the officer in his comments stated that he admitted to him that he had used alcohol. So the violation I placed on him was use of alcohol. The note of condition on rule number 2 of supervision that Mr. Owens signed stated that he understood that he should not use or possess any alcoholic beverage or enter places sold as a primary commodity. On 11/8/21, Mr. Owens admitted to using alcohol by telling the deputy Stalcup that he had 1 shot of Crown Royal. And that was the basis for my request for revocation, was the number of DUIs that he's had in the past and a new alcohol charge, Your Honor.
You want to inquire? Need to get over on camera here.
Mr. Garner, you know, I talked before about this. Do you recall how long he had been on supervised probation under you prior to this incident?
He began supervision August 26th of 2020. And that was a 20 CR9 case.
So if I told you about 14 months, does that sound about right?
Yeah, that sounds close.
Okay. And was he in fact, I think, scheduled to be placed on unsupervised probation the month that he picked up the charge?
He was.
In that 14 months that you had supervised him prior to this, had you had any issues with him?
No.
Was he a compliant supervisee?
He was.
Did he do what you asked him to do?
He did.
When you reached out to him about this incident, was he forthcoming with you?
He was.
Okay. Is this the only violation that you ever had to report on him in that 14 months?
It is.
Okay, I believe that's right. That's all I have for this witness, Judge.
Mr. Judge, you want to redirect?
No, Your Honor.
Okay. I'm going to take under advisement the revocation. But I will tell you that DUIs bother me about as much as anything. It could very well, Mr. Owens had been okay for 16 months or 17 months or whatever. And then he gets in a car and drives again and runs over a school bus. And somebody asks, well, where was the probation and parole officer? Why did he let him go unsupervised? What about the judge? I don't take this lightly. You know, I was talking to some people the other day, something about, you know, one of the things that we do as individuals in order to have commerce and to operate on the roads is we take it for granted that the person operating that motor vehicle coming toward us is going to operate it in a safe manner, going to stay in their lane and not going to be intoxicated. So I'm going to push this out until March 31st to see what happens in the district court and to see what the evidence is, even if he's found not guilty down there. If they prove he was using alcohol and not operating in all probability, I'm going to revoke it.
I understand.
Okay.
He understands that.
Do what?
He understands that.
Yeah, okay. Thank you very much.
Thank you.
Gene Parrish. Circuit Court. Yeah, Mr. Hurt, he was on, it's that DUI isn't here in circuit court. It's not in district court.
It's a DUI 4. That's right.
It's a DUI 4. So you need to be on December 11th. I mean, listen to me, March 11th.
March 11th.
To negotiate in March 31st.
Okay, that's fine.
Okay,
Thank you, Judge.
yeah. Gene Parrish,
Sir.
Commonwealth of Kentucky versus Gene, 19 CR 0040. Are you Gene Parrish?
Yes, sir.
Okay. What are the last four digits of social security number?
95233.
And what's your year of birth?
August 13th, 1989.
Okay, what do you got on this, Mr. Judge?
We have a motion to revoke, Your Honor, and we have he violated, he's failed drug test and he's got 2 pages of violations. So we can verify that with the probation parole officer.
You
Garner.
want to stipulate on this?
Your Honor, we do stipulate to the violations. I do want to clarify that he's stipulating to that he has a new charge. Now that he's been found guilty, that charge is still pending the grand jury.
Well, I mean, I'm talking about all these other violations he's talking about.
Yeah,
Let's
the
just take
current,
some testimony on this if you're not willing to stipulate to all of them.
we are, Your Honor.
Okay, well, I revoke him then, and based upon his failure to comply with the terms.
We would ask the court to send him to long-term treatment if the court would allow.
I'll take a look at that at some juncture if you want to bring it back up in some way, but I'm not going to today. Jamie Pierce. Pretrial diversion to revoke will be sentenced on March the 31st. Jamie Pierce. Hundo versus Jamie Pierce, 21 CR 00103. Are you Jamie Pierce?
Yes, sir.
What's your year of birth?
1989,
Last four digits of your social security number.
4681.
Okay, we're here on a revocation. What's the Commonwealth have to say?
Your Honor, just trying to find what do we- sorry. Your Honor, I think that she's been put in drug court.
We were asking for her to be referred, and Mr. Judd was in agreement, and the Commonwealth was
Yeah.
okay.
In lieu of, I will sign it. What was the violation?
She had left treatment, Your Honor. The court had moved her from one treatment to another. She had left treatment and had her father died. And it was about a 3-week period where she wasn't, 3 to 4 week
Okay, well, I'm
period.
going to sign an order on the drug court situation here. And she'll be held until she can be oriented in the drug court.
Thank you, Your Honor.
Danny State. Commonwealth versus Danny Lee Staten. 20 CR 0020, 20 CR 0021, 20 CR 0070, and 21 CR 0047. Mr. Staten, what are the last four digits of your social security number? Mr. Staten, can you hear me?
7826.
Okay, and the
7826.
okay, the year you were born?
Sir.
What year?
Oh,
were you born?
12059.
1959. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
You have anything to say, Mr. Garrett?
Judge, I would just add one thing. Mr. Staten advised me that there's about 5 months worth of home incarceration that's not reflected on there. I just bring a note to probation and parole that if he's to get credit for that, that they look into the 5 months or 5.5 months he was on the
Well,
bracelet.
See if that's there, and I will give him credit for it if it's there.
But nothing else, Judge.
Okay. Plead guilty to possession of controlled substance meth, shall receive a sentence of 3 years. Upon plea of guilty, that's in 20 CR 0020. Upon plea of guilty to possession of controlled substance, first degree meth in 20 CR 0021, he shall receive 3 years. Upon a guilty plea to engaging in organized crime syndicate in 20 CR 0, he shall receive a sentence of 15 years. Upon plea of guilty to receiving stolen property over 10,000 and 20 CR 00, he shall 70, he shall receive a term of 10 years. The two sentences in 70 shall run concurrently for a total of 15 years. Upon a plea of guilty to trafficking in controlled substance, 2 grams of PFO, he shall receive a sentence of 10 years. The 3 sentences in Cumberland Circuit Court, 20, 21, and 70, and 49, are all run concurrently, a total of 15 years. The 15 years sentence is to run consecutively to the Cumberland Circuit Court, 16 CR 0081, 2508, 42, and Monroe Circuit Court, 46. Now, what's the total there? It doesn't say. Mr. Judd?
Your Honor, I don't know. But
is that 30 years?
We'll get the file out here, Your Honor, and see.
Judge.
Yeah.
If Mr. Garrett wants to go ahead, I was just looking at the plea that was entered, and I can read it to you what it says.
I've got it here, but I can't understand it.
Judge, if I might.
Speak up, Mr. Garrett, loud.
Pages 18 of 28 and 19 of 28 state that he would have received 5 years on one of those cases, being Cumberland 11 CR 008. That was a 5-year sentence. And then Cumberland 16 CR 81 was a 10-year sentence. Based on the PSI as reported, I believe that total would be 15 years for those old cases.
So he's receiving 15 on top of 15, 30.
He's receiving 15 years for this set of cases, 15 that he already has, for a total of 30.
Jeez.
He had 15 years before he got here.
What was the Monroe County case?
That was 6 CR 46, I believe. Let me look. 6 CR 46. The original offer was 30 years.
I'm asking how much time was on the Monroe County case, what I'm asking.
Years.
Well, if he says to 30 years, when will he be parole eligible? All of are any of these C's? Bound to be C's. I mean, even B's, they're all C's.
I believe they're C's.
20%. There's a B.
20 CR 70 goes in the
If it's a B, what do you have?
and also 21 CR. Okay, got me. I'm sorry.
Roll drive for,
Right.
They're at 20% parole eligibility. If you add these. I think it was supposed to stay at 20%, Your Honor.
My understanding, 1 year. He's got 2 years under his belt. If the court gives him the 5 months, he's that much further, but I believe he has 1 more year to the board, maybe minus the 5 months that the court's giving him,
Even after this.
even after this.
Okay, I'll go ahead and enter it then. Yeah, I'll waive the court costs. I'm gonna charge you. He hadn't been in so long, there's no way he has any assets or anything, so waive the court costs. Okay, thank you very much. Bernice Stearns. Bernice Stearns.
Mr. Williams,
Yeah,
I'll say something like, so what is that? I got a total of 15 years or is that
got 15 on top of what you already had, but they said that you'd be eligible to go in front of the board in about a year and a half.
okay, I thought it was, that's what I was saying.
One, I gave you credit for your home incarceration. So they say that you'd be eligible to go in 1 year, okay?
Okay, all right.
Thank you very much. Bernice Stearns.
Your Honor, there's a motion to revoke, but I think the drug court is being considered. Is that correct, Samantha?
She's not on the, she's in jail here. Let's get her on the screen first.
Okay, I'm sorry about that.
Bernice Jones.
Yes, sir.
Are you Bernice Jones?
Stearns.
Starnes.
Yeah, excuse me. I said Jones. Bernice Stearns or you say it Stearns, do you? People say it both ways, don't they?
Yes, sir.
What's your year of birth?
Yeah, they do.
What's your year of birth?
11/29/1982.
And what are the last?
11/29/1982.
What's the last 4 digits of your social security number? The last 4 digits of your social.
0513.
Okay. Okay, we're here on a revocation hearing. What does the Commonwealth have?
Your Honor, I believe that we've had a discussion about drug court. Is that correct?
Yes.
In lieu of revocation.
Let me hear what she's done a little bit.
Okay.
Raise your right hand, please. Swear testimony about to give us the truth, whole truth, and nothing but the truth.
Do Your Honor.
Oh.
You just say what she's
Yeah,
done?
go ahead.
All right. So, the January 28th violation report, I charged her with altering or attempting to alter the results of a drug screen. On 1/20/22, during regular scheduled report day, she was given a follow-up urinalysis from the previous month's positive drug screen. And I had court security down front take her into the latrine, and she was carrying a condom full of urine in an attempt to pass the drug screen. She did not use it, but she did have it in her possession. And then she admitted to and tested positive for methamphetamine, opiates. And then on 1/20, we asked her to come back the following day because it got so late here that day that I didn't want to be alone with a female offender. So I had her come to the Columbia office, and we retested her there. And she provided another sample that also tested positive for the methamphetamine and opiates. And based off the color of her sample that she provided, it was consistent with all the officers' presence, expertise that she had consumed a beverage that is used to alter a drug screen that you can get at a gas station. And then providing false information to probation and parole officer. She denied use of the methamphetamine, amphetamine, oxycodone, and it was sent to the lab. The lab returned positive results. failure to complete treatment for substance abuse. Due to the past positive urinalysis, Ms. Stearns was directed to social service clinician to participate in outpatient counseling. And it's now been determined that social service clinician, that the level of substance abuse interventions previously assigned is inadequate, and she increased the level of treatment based on the lab results and criminal thinking altering the urinalysis. And then on the violation report for February 7th, on 131, Ms. Stearns was directed to return to the Columbia office to follow up with the lab results. And we gave her a second, or her third urinalysis, where she again tested positive for oxycodone, oxymorphone, and noroxycodone. Lab results returned positive screen for those substances, and providing false information to probation parole officer where she denied use again, and it was again labbed, and the sample was again diluted. The lab report does say on both of those that they were diluted, that she had consumed something to alter the drug screen.
Any other questions, Mr. Judge?
No, Your Honor.
Would you, counsel, would you like to cross-examine?
No, Your Honor.
Okay. Okay. Well, there's an old saying that you can lock a thief out, but you can't lock a liar out. And what bothers me most about Ms. Stearns is her continued effort to falsify statements, to alter drug tests. I just don't think that I can do anything other than revoke her. So I'm going to do a revocation, and I hope you, when you're there, I hope you use your time positively and just think about if you'd used all the effort you did to avoid responsibility for a problem that you got, that you could be out in drug court or might not be in jail at all. But I'm just not going to tolerate people coming in and lying to these officers and altering these tests and sending these things off and denying. You're revoked. Candy Stuber and Jonathan Stuber.
Judge, I think that's a pretrial diversion.
Well, I revoked the pretrial diversion, set a pre-sentence investigation warrant, censure on March the 31st. Doesn't say on the docket I have here, it just says revocation. Candy Stuber and Jonathan Stuber. I guess I can call their cases together, convenient cases, right, Mr. Judge?
Yes, sir.
That's true.
Candy Stuber, 21 CR 00131, and Jonathan Stuber.
Judge, we do not have Mr. Stuber here yet.
Okay, well, I'll just do her case then.
Thank you, sir.
Bring him on up, I guess, at some juncture. What do we have on Miss Stuber?
Your Honor, I spoke to Mr. Stockton last night, and we are working out some last minute details on her case. He asked if we could reset this to March 3rd in Clinton County. They also have companion cases in Clinton County.
And is that the same on Mr. Stuber?
Yes, Your Honor.
Okay, we'll continue both of these cases. They'll be next heard on March the 3rd in Clinton County. There's no reason to bring Mr. Stuber up.
Candy, if you want to call me this afternoon or in the morning, I'll explain. Where it's everything we talked about yesterday. We're trying to get it all lined out.
Do you understand that, Ms. Stuber?
Yes, I was just wanting to know, are we gonna be able to get released today?
No.
Not today. But you're getting scheduled on March 3rd, which is almost a month before the next time here, because we're going to hear your case over in Clinton County to try to wrap it all up. Okay? For you and your husband.
At 9 a.m., is that correct on the 3rd?
Do what?
9 a.m. on the 3rd?
Yeah, on the 3rd. Is that a conference day or a court day over there?
Conference.
It's a conference. They're going to conference you. And then when's the next court day over there?
Oh, I thought Jesse told me it was the court date.
Oh, maybe that is the court. It is the court date. I'm sorry.
Okay.
It's on the 3rd. Y'all be over there on the 3rd. And that's a court day, and if the agreement is reached, everything can be wrapped up in both counties from over there on the 3rd, okay? Thank you. Jimmy Webb. Jimmy Webb. You have an arraignment on that? Commonwealth versus Jimmy Webb, 22 CR 0012 and 19 CR 0023. Are you Jimmy Webb?
Sir, Mr. Judge,
Yeah. What's your year of birth?
7766, Judge,
Okay, and what are the last 4 digits of your social security number?
8409.
Okay, we're here today for an arraignment in 22 CR 0012 and also for revocation in 19 CR 0023.
Yes, sir.
You have a right to remain silent. Your attorney's here. The grand jury of Cumberland County charge you with trafficking and controlled substance in the 1st degree. Second offense. Possession of drug paraphernalia and being a persistent felony offender. Mr. Bailiff. Counselor, you acknowledge the ability of your client receiving indictment, await formal reading and arraignment, enter plea and not guilty, reserving all pretrial motions.
Yes, Your Honor.
Now, are y'all gonna try to resolve all these together? Okay,
Yes, Your Honor.
I will
Yes,
schedule
Your Honor.
this. I'll schedule this for conference on March 11th and the next court date on the 31st, and I'm signing the reciprocal discovery order. Mr. Webb, they can share the information with you. They have a new case. Your attorney will meet with the Commonwealth and you on the 11th. You'll be back here in court on March 31st, okay?
Mr.
Thank you.
Judge, can I say something, sir?
Probably. What do you want to say?
It was to my understanding, my lawyer, Mr. Levitt, talked to the prosecuting attorney, Mr. Stockton. It was my understanding they had some kind of plea worked out for today for me to go to drug court. I don't know whether they brought that to your attention or not, sir.
She says that there's no agreement yet. That's what y'all gonna talk on the 11th about what they can do with both your cases, okay?
Okay, thank you, Judge.
Okay, you have a good day. Jerry Winningham. Okay. Commonwealth versus Jerry Winningham. 21 CR 0096, Commonwealth Kentucky versus Jerry Winningham. Are you Jerry Winningham?
Yes, sir.
What's your year of birth, sir?
12/5/75,
What are the last 4 digits of your social security number?
8344.
Okay. I understand that you have a plea agreement, is that correct?
Yes, Your Honor.
Is it a diversion or a felony plea?
It was a felony plea, Your Honor.
Okay, a motion's been tendered, sir. It says you wish to enter a guilty plea today. Is that correct?
Yes.
Okay, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment
Yes,
number
sir.
21 CR 0096? Have you had
Yes,
plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed all the evidence? You feel like you're fully informed about your case?
Yes, sir.
Okay, you do not have to enter a guilty plea today. You have certain rights. And before I can accept a guilty plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to higher court. If you lose, you have a right to require the Commonwealth to prove you to be guilty beyond a reasonable doubt of the charges against you. You understand that by entering a plea here today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may play any range of sentence allowed by law. I do not have to, prior to accepting the recommendation, I will await a pre-sentence investigation report. from probation and parole. In the event that I do not accept the agreement, I'll inform you, you withdraw your plea. Mr. Judd, what is the agreement? And
Upon a plea of guilt, I'm sorry.
Go ahead.
Upon a plea of guilty to possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a $500 fine. The 3-year sentence and the 5-year sentence shall run concurrently for a total of 5 years, serve 120 days in jail, with the balance probated for 5 years supervised. The defendant shall receive credit for time served. The defendant shall pay court costs at the discretion of the court. The defendant shall remain on active supervision until all restitution, fines, court costs are paid. The defendant shall obtain gainful employment or do a minimum of 30 hours per week community service. And the defendant agrees to have any and all contraband and drug paraphernalia disposed of in accordance with the laws of Kentucky.
Is that what you agreed to, sir?
Yes, sir.
Is anyone, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Knowing your constitutional rights, I've explained to you, is still your desire to enter this plea, give the court the authority to fix your punishment within the range permitted by law?
Yes, sir.
Can you hold the signature up? Can you get the signature?
I provided the documents already, Your Honor.
Send me the signature. So can you, I guess we're off the other system.
Mhm.
There's a document purports to have your signature on it. Did you sign that document?
Yes, sir.
Okay. I'll accept the plea, order a pre-sentence investigation report done and do sentencing on March 31st. Thank you. Timothy Ray, they're going to do a pre-sentence investigation report on you, be sentenced on the 31st. How much of this time does he have in by then?
He's close, Your Honor. He did have a request if the court would grant him $1,000 bond at this, cash bond at this time to release him.
I'm just going to, we'll probably release him in sentence.
Okay.
Okay. Timothy Ray. Timothy Ray. Timothy Ray. The next case.
Your Honor, please, I have information you absconded. And we've got a motion to revoke and revoke the bond. I think his mother's on a $15,000 bond.
He's in jail.
Okay.
Yeah, he was picked up after our last settlement conference, Your Honor.
Okay. Welcome back, Mr. Ray. What's your year of birth?
99.
And what is the last 4 digits of your social security number?
3132.
What do you want to do on this now? You know, scheduling for the 11th for conference and
Revoke the bond. And yes, sir.
Bond is revoked to be held without bond. Okay, now, the only other case we have on the docket, we have any other live cases except Jimmy Otterson? What else you got? Michael Birdwell. Let's do Michael Birdwell.
Judge, we have several more on the docket that we missed. We had Mr. Shannon Walters. We also have Michael J. Nethery. The young Mr. Nethery is now in the jail. And we skipped over Brandon Hall, Your Honor, the 21 CR 157.
Keisha Crawford.
You mean anybody, Mitch?
Keisha Crawford as well. We have her.
And Ms. Crawford.
Wait just a second here. Yeah, Michael Birdwell, we had him out of custody. It's the reason we missed him. He's in custody now. Commonwealth versus Michael Birdwell. That's the one. He's here for the purpose. Is he here for the purpose of arraignment? Yeah, and I think your mother is here wanting off the bond, and so he's in custody, you're released from the bond. Okay, thank you. Commonwealth of Kentucky versus Michael Burgle, 22 CR 004 and 22 CR 008. On 004, we're here for the purpose of arraignment. Grand jury of Cumberland County is returning an indictment charging you with possession of controlled substance and failure to eliminate registration. And in 22008, Commonwealth of Kentucky has charged you with possession of controlled substance in the first degree, possession of marijuana, possession of drug paraphernalia, and one headlight. You acknowledge the identity of your client, waive formal reading arraignment, acknowledge receipt of indictment, you're pleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Scheduling for the 11th and the 30th having been held without bond. Okay, now, Michael Nethery. Michael Nethery is next. Michael Nethery. Well, I got him on the other docket.
Yeah, he's on for arrest.
Commonwealth of Kentucky versus Michael Nethery, 22 CR 002 for arraignment. And what's the other? 19 CR 68 for revocation. You are Michael Nethery.
Yes, sir.
Last four digits, social security number 6144.
Yes, sir.
And year of birth 1988.
Yes, sir.
Grand jury, you have a right to remain silent. Grand jury, Cumberland County's returned indictment charging you with possession of controlled substance of first degree, possession of marijuana, possession of drug paraphernalia, failure to maintain motor vehicle license, failure to eliminate registration, unobstructed vision of windshield. Mr. Bailiff. Counsel, you acknowledge the identity of the client, proceed indictment, waive formal reading arraignment, enter plea or not guilty, reserving all pretrial motions.
Yes, Your Honor.
The other case will be, the revocation will be held in abeyance. You'll meet on the 11th and the next quarter, March 11th, the next court appearance on the 31st, you held without bond. Now, is there anybody else that we have waiting there, Mr. Jailer?
Yes, sir, Judge. We have Keisha Crawford.
Yeah, here she is. She was on the, I see her here. Commonwealth versus Keisha Crawford, 21 CR 00147. Keisha Crawford. Is that the last? Then you got.
No, Judge. We'll still have Brandon Hall and Jimmy Otterson.
Okay.
Shannon Wolf.
And Christian Jones.
Oh, Jesus. Commonwealth versus Christian Keisha Crawford. Are you Keisha Crawford? Are you Keisha Crawford?
I am.
This is 21 CR 00147. Are you what's your date, your year of birth, ma'am?
1998,
Or last four digits, your social security number?
2982.
Okay, we're here today on a pre-trial conference.
You have an agreement, Your Honor. I provided the plea paperwork.
Is it felony?
Felony.
A motion has been filed that says you wish to enter a guilty plea today. Is that correct?
Yes, ma'am. Yes,
Are you
sir.
currently under the influence of drugs or alcohol?
No.
This is plea freely and voluntarily given. Are you the same person named in indictment number?
Yes.
In indictment number 21 CR 00147.
Yes.
Have you had plenty of time to look at this thing with your, consider these matters with your attorney? Are you satisfied with their advice?
Yes.
Have you looked at all the evidence the Commonwealth has against you? You feel like you're fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. You do not have to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. You understand that by entering a plea of guilty, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have a right to withdraw your plea. What is the Commonwealth's recommendation?
Upon a plea of theft, unlawful taking disposition over $10,000, the defendant shall receive a sentence of 5 years probated for 5 years supervised. The defendant is currently incarcerated and shall receive credit for time served and be released from incarceration upon final sentencing. The defendant shall pay restitution in the amount of $1,900 to the Cumberland Circuit Clerk at a monthly rate of $100 with first payment due within 30 days being released from incarceration. The restitution is subject to a 5% clerk's fee and is to be paid jointly and severally with co-defendant Shannon Walters. Restitution shall be dispersed in accordance with said restitution order submitted with this plea. $500 currently held as bond money in Commonwealth versus Shannon Walters in indictment number 21 CR 0062 shall be applied to the restitution above case, leaving the final restitution balance as of $1,400. The defendant shall pay court costs at discretion of the court. The defendant shall remain on active supervision until all restitution fines and court costs are paid. The defendant shall obtain gainful employment to a minimum of 30 hours per week community service. The defendant agrees to have any and all contraband and drug paraphernalia disposed in accordance with the laws of Kentucky.
Ma'am, is this your understanding of your agreement with the Commonwealth?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Knowing the constitutional rights I previously explained to you, is it still your desire to give up those rights, enter a guilty plea, and allow the court to fix your punishment in the range permitted by law?
Yes, sir.
You understand that after entering this plea, any future convictions can be enhanced as far as range of penalty because of these pleas. You understand that?
Yes, sir.
I have a document here that has this agreement in it and has your signature on it. Did you sign that document?
Yes, I did, sir.
Okay. I'll accept a plea order pre-sentence investigation report. Have you sentenced on March 31st? Probation parole officer will be in contact with you up at the jail to get information for your pre-sentence investigation. Okay.
Thank you.
Yeah. And we have Keisha Crawford still on there.
That's who we just did, Your Honor.
Was she on there for anything else?
No, Your Honor, she just had
That's
a
the only
single claim.
charge. I thought she had a revocation too.
No, Your Honor, this was her first charge.
Okay.
Judge, we've got Shannon Walters coming.
And he has 2 cases.
I don't see him on there, period. Yeah, there he is. There he is. Lost him off a mistake. Who else do we have? Yeah, we have Otterson. I'll get to you. Was Hall in or out of custody?
He's in, Your Honor. He's on for sentencing.
Commonwealth versus Shannon Walters. 21 CR 0062, 21 CR 00146. Are you Shannon Walters?
Yes, Your Honor, I am.
What's your year of birth?
3778.
Okay, and the last 4 digits of your social security number.
8119.
Okay, what do we have on this?
We have an agreement, Your Honor.
Felony? or-
Felony agreement.
Motion's been filed that says that you wish to enter guilty plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your
Is
Honor.
the plea freely and voluntarily given?
Voluntary, sir.
Okay. Are you the same person named in indictments number 21 CR 0062 and 21 CR 146?
Yes, Your Honor.
Having reviewed the evidence that the Commonwealth has against you, you believe you're fully informed about your case.
Yes, Your Honor, I have.
Discuss these charges with your attorney. Are you satisfied with her advice?
Yes.
Before I can accept a guilty plea from you, you have certain rights. I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to require Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand that during a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may also apply any range of sentence provided by law. I do not have to accept it. Prior to accepting the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event I do not accept the recommendation, decide to impose a harsh sentence, you will have the right to withdraw your plea and proceed to trial. You understand all that?
Yes, Your Honor, I do.
And what's the Commonwealth's recommendation?
Commonwealth agrees to dismiss indictment number 21 CR 00062, possession of drug paraphernalia. Upon a plea of guilty to indictment number 21 CR 00146 for the charge of theft and unlawful taking or disposition over $10,000, the defendant shall receive a sentence of 6 years. The defendant is currently incarcerated and shall receive credit for time served and be released from incarceration upon final sentencing. The defendant shall pay restitution in the amount of $1,900 to the Cumberland Circuit Court clerk at a monthly rate of $100 for first payment due within 30 days of being released from incarceration. Restitution is subject to a 5% clerk's fee and is to be paid jointly and severally with co-defendant Shannon Walters. Restitution shall be dispersed in accordance with said restitution order submitted with the plea. $500 currently held as bond money in Commonwealth versus Keisha Crawford, Cumberland indictment number 21 CR 0062 shall be applied to the restitution in the above style case, leaving the final restitution balance of $1,400. Upon a plea of guilty to indictment number 21 CR 00062 for the charge of possession of controlled substance first degree, the defendant shall receive a sentence of 3 years. The 6-year sentence in indictment number 21 CR 00146 and the 3-year sentence in indictment number 21 CR 0062 shall run concurrently for a total of 6 years, probate for 5 years supervised. The defendant shall pay court costs at the discretion of the court. The defendant shall remain on active supervision until all restitution, fines, and court costs are paid in full. The defendant shall obtain gainful employment or do a minimum of 30 hours per week community service. The defendant agrees to have any and all contraband and drug paraphernalia disposed of in accordance with the laws of Kentucky.
What's the court cost?
Both cases combined is $425 without the restriction.
In addition to the restitution, that'd be $425 court costs, and I'll let you pay that at $30 a month in addition to the restitution, so it'll make it affordable for you, okay? Start the first payment 30 days out. Is that, you signed this document, is that your signature on the document, agreed to all this?
Yes, Your Honor.
Okay. Accept the plea or the pre-sentence investigation report, have you sentenced on March 31st? You what? Okay. You got anything else up there? In there?
We got Christian Jones.
Yes, sir.
So we got Jimmy Alderson and we got Christian Jones.
No, we have Brandon Hall, Your Honor.
Well, let's do Christian Jones first.
We've already done him, Judge.
So they just told me.
You had moved him to the end of the docket to see if you want drug treatment, and he said yes.
Okay, Christian Jones, we already did Christian Jones and he asked if he wanted drug treatment. So you can just tell him that I'll agree to sign.
Here he is, Your Honor.
Christian, do you agree to go into long-term drug treatment?
Yes, sir.
Okay.
Is there anybody?
Yeah, I'm gonna authorize that. Now, who you want to have to find that?
We would ask probation parole since he's on probation.
Can y'all do that?
Yeah, Your Honor.
Okay, we'll get you a bed as soon as we can. And so
Is there not any idea about how long that might take?
as soon as possible. It won't be as long as you think.
The only reason I ask, Your Honor, is because I've got a 7-month-old baby boy, just born up, and I haven't spent that much time with him.
But we'll get you, you're gonna be in long-term drug treatment. You're not gonna be coming and going.
Oh, I understand that.
Okay, thank you.
Okay.
Thank you, Judge. That's all I have.
Yeah.
Thank you.
Now, I want to call Jimmy Otterson up next.
All right, Judge, just one moment.
Well, who you got here?
This is Brandon Hall, Judge. He's the last one before Mr. Otterson.
Okay, Brandon Hall. Brandon Hall. Where on the docket was? Commonwealth versus Brandon Hall, 21 CR 00157 here for sentencing. Are you Brandon Hall?
Sir,
What are the last 4 digits of your social security number?
3773.
Your year of birth? Your year, what year? What year?
1882.
Okay, we're here today for sentencing, is that right?
Yes, Your Honor.
Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes.
Is it substantially correct?
Yes.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On the plea of guilty, the Commonwealth made the following recommendations which are accepted. Upon the plea of guilty to possession of controlled substance, first degree defendant shall receive a sentence of 1 year to serve. The defendant stipulated probable cause, thus this 1 year shall run consecutively to 21 CR 0054, 21 CR 116, and 21 CR 0026. He shall pay a court cost of what amount? $215 payable $30 a month. First payment due in 30 days after you are released from jail. Okay. Okay, thank you very much.
Your Honor, we had taken up Mr. Garrett earlier, and the court had asked me to ask him if he wanted to withdraw his plea or be sentenced to the 5 years to serve. He does wish to withdraw his plea at this time. So if we could.
Figured as much. We'll just set him a trial.
Your Honor, if the court wouldn't mind if we could set it for a settlement conference to see if we have before setting a trial date. I know it won't be probation. I understand that.
11th,
Yes.
set for 11th to negotiate. And then for the first. Now let's get to Mr. Otterson. Do what?
Agreed orders to sign from Monroe County. I've got to go pick up my son from school, and I'll take those with me and send them to the clerk's office. There's 2 more, Judge.
You dated and delete.
Okay.
Mr. Garrett mentioned these. Mr. Garrett, is he gone?
He's gone.
He's paying for these things.
Yes, that's what they say.
You want to have them sent from here so you don't put it?
No, I'll take those because they're. Thank you.
Yeah. Jimmy Otterson. We're on a pretrial conference. Mr. Bates is present. What's the deal on this case here, Mr. Judd?
Your Honor, all I know is that I think it's ready to be set for trial, but the Commonwealth would recommend be set for July or after.
Okay, you got your
That's the
calendar
case.
with you?
I do, Judge. Can I take my mask off?
Yeah.
Judge, I'll say this, and I have spoken to Mr. Stockton. There's a possibility of working this case out. The problem has been that there is a federal case and there's an unindicted case out of this county as well. Mr. Stockton and I had tried to get the federal authorities to go ahead and resolve their case. And then we were going to do whatever we were going to do in conjunction with that. And that has been the biggest reason for the delay and why this case has been going on and on and on. After Mr. Stockton was taken into federal custody, he was then returned at one point and nothing had really been done. At this point, I have talked to Mr. Stockton about the possibility of working this case out because the case that's actually before Your Honor is not really the biggest case that Mr. Otterson has. He's got the other unindicted case and of course the federal case that we may be able to work this case out and then do what we need to do on the federal side. So with that said, Mr.
You want to
Stockton.
say it for March 11th to negotiate one more time?
That would be fine with me. Now, if they have instructions on getting a trial date, that's fine because we did not have any kind of a deal in place. We had just discussed it.
We don't object to having another
Negotiate
negotiation.
on March 11th and the next court date would be March 31st. Okay. Now, the other matter is the show cause hearing. Mr. Bates, I find you to be very well prepared and very pleasant and easy to work with, but you cannot decide when you're going to come and not come.
Judge, this is the first time ever that I've ever had this issue.
Yeah.
I don't know.
That doesn't surprise me because you're very diligent and everything, but I just got to make sure this case here has got to move at some juncture.
Absolutely.
He's been incarcerated for a long time.
That is absolutely.
And I take very seriously how long people are incarcerated without a trial, as you do.
Yes,
Judge.
Judge.
So, I mean, it bothered me when you just didn't show up, but I understand. Could you explain to why you didn't make it?
Well, Judge, first I want to say that there is no explanation for any of this. Yeah, I am responsible for it either way. Now, last month I was sick, but I do think I was back at work. I will also say, I don't think I'm receiving the court's orders. I did not know. Now, that said, I'm not trying to blame this on anybody else. This could be an issue with my office. But other than that, I take full responsibility, Judge.
Well, I appreciate that. And I'll withdraw the show cause order based upon that. I think you're an honorable man, do a good job. Now, I want you to make sure, though, that you are there on the 11th and back here on the 31st so we can see what's going on. And if there's not going to be an agreement with the feds, then we need to get this guy a trial on what they have in front of them.
That's exactly what Mr. Stockton and I spoke about
Okay,
last time.
thank you very much for your patience and for being here today.
That's okay, Judge.
Have a safe drive home.
If I could ask, what is your policy on video? Because I think that's part of my
On cases like this, we prefer the attorney to be present if there's anything substantive to do. If it's just a scheduling thing or whatever. But, you know, in Mr. Otterson's case, it could very well be at some juncture that we'll start transporting him. We're avoiding transporting because of going in and out of that jail up there exposes people to continued COVID. But, you know, I usually prefer the attorneys to be here to talk to the Commonwealth one more time. It's just like a conference. So the attorneys are expected to be here except in an exceptional situation. Okay, thank you very much. Have a safe trip. Okay, is there any other? Mr. Otterson, they're going to discuss your case on the 11th, and then they're going to bring you back up to see if they can move this case if the feds aren't going to do anything, or at least inform you what they're going to do. Okay?
Yes, sir.
Okay, thank you. Is there any other matter to come before the Common Circuit Court? Mr. Judd, do you have anything else? You got one in your pocket?
Oh, Your Honor.
Okay. Well, it is 1:14 and it's time for the child support docket. Thank you.
Now,
Okay, let's go off the record.
Your Honor,
Yes.
did we still need to take up Mr. Birdwell again? We still had him holding him, just making sure that you didn't need him, Your Honor.
We don't need him for anything else. Thank you.
Thank you.
Yeah. I'm gonna call the child support docket here. Joseph Dwayne Grider, Adam Bowe, David Pennington, Jerry Leon Walker, Billy Fairley, Brian Brown, Sarah Cowgill, and Seth Roberts. Appropriate order to be entered in those cases. Now, 1:15, it's time to call the civil docket. Teresa Morgan versus Cumberland Valley Manor, 16 CI 00018.
Good afternoon, Your Honor. Rebecca Schaefer on behalf of Cumberland Valley Manor.
Your Honor, Lisa Cercio and Heather Warren here for the plaintiff in this case.
Okay. Mr. Dodd, are you involved in this case?
No, sir.
Okay, we'll turn your camera off then. When I call your case, you can turn it back on so we'll have a record, okay?
Yes, sir.
This case is 16 CI 0018, was a mutually agreed upon status conference, I believe. Is that correct?
Yes, Your Honor.
I don't guess we have you. Are we picking her up on that? Okay.
Yes.
Okay. We had some problems earlier today.
Your Honor, would it help if I lower my mask, or what do you prefer?
I'm just worried about the record. I don't care if you lower your mask.
Okay.
Now, this status conference, I've looked, it looks like there's still depositions that are to be taken. Is that correct?
Yes, Your Honor. And I believe the main purpose with this motion for status conference is we have two pending motions. One was a motion for partial summary judgment on behalf of defendants. And then there's a motion to compel on behalf of plaintiff. And
well, let's deal with the motion to compel on behalf of the plaintiff. I looked at that. What do the plaintiffs feel like are owed to them that they don't have?
Your Honor, this motion was filed quite a while ago, and the defendant by prior counsel. There's several issues in there, including incident reports. Let me get this motion pulled. I don't know that the defendants filed a formal response or if it was argued because it was prior to our taking over.
Yeah, we did file a response. And I believe that there was also then a reply by plaintiff's counsel, and then we filed a SIR reply to kind of clarify some items, and it was argued.
Okay. Yeah, and so there were issues regarding incident reports, and there's probably going to be a few other issues we need to meet and confer, but this was argued a while ago. And I think we just need to get an order on that and the summary judgment, and I don't know if the court wants to.
Well, I'd like to talk about the sovereign immunity issue. That's what we're talking about right now. And in full disclosure, as I was reviewing the documents either yesterday or the day before, and I go down through the documents and I see that my late father, may he rest in peace, was one of the original incorporators. He was county clerk at the time, and I won't disclose that. He's been deceased for several years, and that brought to my mind that he had been on the board down there at one time, but he's been deceased for many years. And I wanted to bring that to attention to plaintiffs in that situation. So you don't have to make a decision on whether you would request for me to recuse or not today, but I felt like I'm obligated to tell you that.
I appreciate you telling us that. I guess we probably just need to discuss it with our client.
I think you would. So I just put you on notice of that. Now, the other thing that I would say is sovereign immunity is one of the things that I know least about of anything, because it's one of the most vexing things that I can look at. But I did go back and look at the articles and how the articles down here are distinguished from some of the case law.
Mm-hmm.
I don't know whether I'm convinced of that. I see the difference in the way things are worded, but I don't know what that entity is. If it isn't a part of this municipality, I don't know. I don't know what it is. I mean, it's just so you're saying if it's a nonprofit standing out there that leases the building from the county or whatever, that sovereign immunity wouldn't apply. Would that be your argument?
Right. That they're not, it's not quite as clear cut as they are just for the purpose of the county.
Well, do you know of any other case that fits this scenario that we have here? You know, of what the articles say, why it was incorporated, and whether or not. I mean, it seems to me to be a distinction without a very big difference, because I think that was it the Metcalfe County?
Yes.
It was a Metcalfe County case. It appears to me that these are two very similar counties that organized a nursing home to serve the people of these small counties, because nobody else in the private sector was going to come in because of the population. In my opinion, during my years in the legislature, I dealt with certificates of need and other sorts of things like that constantly, it seemed like. But do you think it makes the defendants, what would you say about this distinction with the Metcalfe County case?
Well, Your Honor, I don't believe that I would agree with the court that it's a distinction without a difference, because you still have the fact that if it under the Articles of Incorporation for Cumberland Valley Manor, if they are dissolved, all of the assets go back to the county. The board is comprised of they basically they vote on who's going to be on the board, and it's residents of the county. And I think that you still meet the criteria that are required under the Kentucky case law, which is the Metcalfe case, which relies on com air, which is still good law, where it asks the two questions. Was it an entity that was created by a county government? And it certainly was in this case. It was the county government who created the entity and set up the board.
Tell her, Angie, you're keying the mic here, okay? So you need to go outside if you want to talk to your client, okay? Thank you. Excuse me.
And then with regard to the second factor, which was does it serve a purpose that is important to the state? And under the Metcalfe case, it's the exact same purpose. They're providing nursing home services to residents of not only the county, but they also allow residents from other parts of the Commonwealth as well. So I think, our position is, and I think it's outlined fairly clearly in our briefing, is that it does meet the criteria of Metcalfe and com air, and any subtle, differences within the Articles of Incorporation, again, are a distinction without a difference.
Okay. You have anything else you want to say about?
Garner, if I could reply with regard to the sovereign immunity issue. This is Heather Warren. I'm here as co-counsel with Ms. Cercio. And with regard to the issue of sovereign immunity, the court hit the nail on the head. This is an issue that has vexed the courts for years. And the Court of Appeals has dealt with sovereign immunity, and they dealt with sovereign immunity in the case of Metcalfe, which the court seems to be well aware of and understands the implications of Metcalfe. However, in this case, after this briefing was filed and after these hearings have occurred, the Supreme Court of Kentucky has actually taken up a couple of cases dealing with sovereign immunity, particularly with regard to care being provided to elderly citizens in the community, specifically with regard to the Bluegrass Area Development District type of organizations providing in-home care for community members in certain communities. In that case, Your Honor, it was not briefed, and perhaps maybe a supplemental briefing would be appropriate here because those decisions.
Well, does Bluegrass have sovereign immunity itself?
It doesn't. They actually ruled, the Supreme Court ruled that in the area of in-home care for elderly citizens needing assistance, it was not a government function sufficient that sovereign immunity would cloak them.
I didn't know. Did they say whether in any case does Bluegrass have sovereign immunity?
This case dealt specifically with the area development district's activity in caring for elderly citizens in their home.
So they must have thought that under certain circumstances, they might have had sovereign immunity. It's just in this circumstance they didn't. Is that what you're saying?
Your Honor, I'm not sure that they specifically distinguished in that case that in certain circumstances it would in fact have sovereign immunity.
You got these quasis all out there, and I'd always wondered, I never have seen a case with these quasis. I mean, a lot of them are brought into the pension system and a lot of other things, but you don't, some of the statutes set out that they're instrumentalities of the state government. Some of the statutes don't. I didn't know where the area development districts were or not. I just thought that was just an aside.
Certainly, and Your Honor,
I'm not going to go ahead. Go ahead.
No, that's fine. The Supreme Court of Kentucky, in dealing with those cases, they looked specifically at the fact that in these scenarios where the area development districts were providing this in-home care, it was a function that was performed also proprietarily and not necessarily a function that the people of the Commonwealth rely upon the government to perform, and therefore not an essential function of the state government. So they distinguish that. And here, Your Honor, we have proprietary nursing homes that perform the same function. It's not necessarily a function that is integral to state government. It's one that's performed in a private setting and also in a public setting. So the Supreme Court certainly differentiated there the function that the nursing care in-home care facilities were performing and found that sovereign immunity did not apply there. I'm gonna let y'all.
You convinced me that I need a supplemental briefing on that issue. So I'll give. Once y'all simultaneously brief that and give it to me, and then I'll give y'all an opportunity to talk to your client about. I don't really feel like that the level of my father's involvement as a county clerk, as one of the original incorporators, he wasn't involved in drafting anything, but I think that probably needs to be there, and he's been gone for a long time. So I'll let y'all get back to me on that and present arguments on why I ought to recuse. I'm not saying I'll necessarily recuse. I just want you to get in the record the reasons that you think I ought to recuse if you think I should. And obviously I will not be offended by any of that because people file motions for folks to recuse all the time. Okay, is there anything else? I guess when the last deadline for depositions was like the 15th, there's something 14th or 15th in one of the pretrial orders. What is that date?
Yeah, Your Honor, that order is with regard to conducting expert discovery, and it's we've agreed with plaintiff's counsel to push that out a little bit just because of scheduling issues. I'm going to be taking plaintiff's expert depots over the coming month, and that will be completed by March 31st. We are then going to file our expert disclosures by, I believe it's like April 10th or 11th. And then at that point, and then if plaintiff desires to take the depositions of our experts, we'll certainly get those scheduled. So, I mean, I think that at this point, we're probably done with regard to fact discovery depositions. We just need to kind of wrap up the expert discovery part of this case. And then at that point, hopefully we'll be ready to come before the court with a motion for a trial
Well, I
date.
will say if the expert witnesses lined out by the plaintiff testifies what they allege to do, it could be a relatively devastating sort of case. But, you know, I just read those, just what they thought they would say. But I guess we wouldn't have a case if they weren't going to say something, would we?
Your Honor, and I think there may be some document production issues we need to clear up, but we can schedule a meet and confer with Ms. Schaefer.
Okay, we can do that. And we can, you don't also won't have to wait till rule days if you want to get on the record by agreement so we can advance this case forward. I'll be glad to do that because this case has been hanging out there for quite a while. And I try to, you know, keep my docket looking pretty good.
It makes sense. What time are you thinking for the supplemental briefing on this? 10, 14 days, something like that?
Why smart people like y'all, you probably do it in 5 days. You probably got those already. And no, I'm just.
We actually do have a brief on this, so
Yeah.
we probably could. And then. could
See,
we
if I'd known y'all when I was practicing, I could have called you up and tried to buy those briefs off of you to save me.
We can sell them.
Will 15 days each be enough?
That's fine, Your Honor. And then.
And then 5 to reply?
Sure.
15 each simultaneously and 5 to reply.
Yes. And then can we just contact your office, just put us down for a hearing date, maybe on that and any remaining discovery issues?
I'll just wait till you decide. Do you want to get with us? You can just call my office. My staff lawyer is there, Ms. Thompson, and she's on the line now watching. And so when it gets down to that, we can schedule something in short order, and we can give you a trial in short order. So you need, if you think that we're going to go to trial, have y'all mediated yet?
Yes, we have, Your
It
Honor.
didn't work out very well. Then.
It did not.
Yeah. Well, okay. What we'll do, it won't be, the only thing will be limitation on you getting the speed of your trial would be how quickly you can line your experts up, because I've got stuff this year. I've got stuff, you know, I mean, so we can go to trial pretty quick. Okay. Okay. Well, thank you all for your patience.
Thank
Have a
you.
great day. Bye.
Thank you, Your Honor.
20 CI 0046. Sunshine Jones versus Jacob David Jones. Coleman Hurt. Coleman Hurt. Mr. Hurt. Sunshine versus David.
Judge, this is my motion for post-decree enforcement to refer it to the master commissioner. They entered into a property settlement agreement. The ex-husband left town and his whereabouts are unknown. Property settlement agreement is very clear that he is to sign a quitclaim deed over to her within 30 days. That was something like a year ago, and he
Give me
hasn't
an
done.
order now, appoint a special
Thank you,
commissioner.
Judge.
There's one sitting right there that you can point. Okay.
I'll take it over, Judge.
Okay. Commonwealth of Kentucky versus Martha Keene and others. Mr. Upchurch, are you on the line? Need to turn your microphone on, Mr. Upchurch.
I'm sorry, Your Honor. Good afternoon.
David Cross involved in this case?
He is, Your Honor.
Mr. Cross stopped by my office earlier and asked for me to send him the Zoom link so he could participate. And
He said what?
he asked for me to send him the Zoom link so he could participate that way, and I sent it to him earlier this morning.
Well, I guess he was so thankful to get off the docket and out of here that he might have forgotten. So, Megan, could you call him and we'll go to these other cases?
I will.
Okay, and now we got, Mary C. Moore and others versus Emily Moore, Coleman Hurt.
Versus Carl Spears.
Yeah, I'll get, let's go down to here. Mr. Upchurch, you want to turn your camera off? We call you again.
Could I renotice?
Yes, sir.
You know, Mary Moore and Emily Moore needs to be, are you
Yes, sir.
withdrawing that motion? Okay.
I'll renotice. Thank you.
Okay. Philip Capps versus Rebecca Sue Rush and others. Do what? Thing here.
Yes, I continued to March 31st. That would be fine.
The lawyers continued it to March 31st. Is that right, Miss Megan? March at what time?
1:15.
1:15. Okay.
Okay, thank you.
Yeah. Okay, let's go back. Mr. Upchurch, you turn your camera back on. We got Mr. Cross. This is a motion is set for trial here in the case of Martha Keene and others. Now, are some of the parties in here deceased now?
Your Honor, I told Keith by letter that I hadn't heard from Miss Keene in some time, some years actually. I don't think she's passed. That was a little
But
awkward.
it said in others. I'm not accusing her of passing.
Yeah.
It said in others, and I didn't know who else was involved in it.
Yeah. But I have not been able to reach her.
Your Honor, the et al. I can explain. There was a bank involved at one time that had a mortgage on the place, and Ms. Capps informed me that the bank has released their mortgage previously. So the et al. Was the bank.
Well, where are we on this thing? There's an offer, there was an appraisal.
Yes, Your Honor. We offered ages ago, we offered $3,550 for the acquisition. The commissioner's award in the case was $38,000, which you can see the dilemma that we're in. My proof at trial will be $16,000. So we're not talking about enormous sums of money, but there is a spread.
Well, that ought to get you renewed interest, Mr. Cross, in the case.
Well, Your Honor, Miss Keene took the money and
$3,000 or what?
No, the commissioner's award. She took the commissioner. So this is one of those situations that I don't know if it can ever be reobtained. But anyway, I'd need to try. I've tried to get a hold of her, and I think she.
Well, she still owns the property, doesn't she?
As far as I know.
You got a lien on it, don't you? Don't you have a lien on it for the amount you advanced? Mr. Upchurch?
I'm sorry, Judge, I didn't.
Don't you have a lien on it for the amount that you advanced? There's a list pendants or something in there.
We certainly filed a list pendant, Your Honor. Yes, sir.
Yeah, so, I mean, the property will stand good for it if there's any money to get back.
Right.
Yeah.
Well, Your Honor, I need to
Let's
try.
reschedule this for March the 31st, and you need to try to get her in and see what she wants to do about that. I'd say we probably need to schedule a trial.
I will make every effort, Your Honor, and hopefully I'll probably just have to go see her, but that's part of it. And Keith, I'll let you know before the 31st what I find out. Okay.
Thank you, David.
Okay. Okay, and now we have Commonwealth of Kentucky versus Carl Spears and others. Mr. Judd.
Yes, Your Honor, I'm here.
Yeah.
Present.
Yeah. Okay, there's a motion set for trial. What did the appraisers do on this one here?
Your Honor, whenever Mr. Judd probably has better information, unfortunately, than I do. Whenever I inherited this case a few years ago, I got a woefully incomplete file. I'm not sure at the present time what our original offer was. I do know that the commissioners put $363,000 on the acquisition, and our proof at trial is $100,500. So there is an enormous spread in this one as well.
Your Honor, similar to the case that you just heard with Ms. Keene, Dr. Spear and his wife have taken or withdrawn the Commissioner's Award, and I am in the process of trying to contact them. I got about, with the mail running the way it does, and I'm certainly not in any way blaming Mr. Upchurch, but the mail coming from Somerset to Bowling Green goes to Nashville these days, and I had about 2.5 days to try to reach Mr.
Okay, let's
Dr.
reschedule this one also on March 31st, and maybe y'all can talk to each other in the intervening time. I can
Yes, sir.
get trials pretty quickly, but you'll have expert witnesses to make sure they can appear on both these cases.
Judge, I have a larger problem. Our expert was Norman Christie, and Mr. Christie is incapacitated at this time and believed to be in a nursing home up in Taylor County. So the plaintiff is going to need to reload, and that's going to take a significant amount of time, Your Honor.
Well, it won't take us, what is a significant amount of time to 2009 case?
Fair point, Your Honor.
Well, if I live, I've got 8 years and 10 months. I hope to get rid of this case, but not pass it on to my successor. So,
Yes, sir.
Yeah,
couple 3 months, Your Honor.
Well, why don't you take a look and see what you can find there between now and March the 31st, and then get us a reasonable idea of what it might take to get your expert witness together. Or we can put it out if it suits both of you. We'll put it out to April 28th. Would that suit both of you better? Or?
It would
I'm fine with either day, Your Honor.
Okay, well, let's do April 28th and have your new expert identified and sent 10 days before that date to Mr. Upchurch. And that way we'll get the thing moving and see what your clients want to do, Mr. Judd, okay?
Yes, sir, Your Honor. Thank you.
Thank you all very much for your patience.
Thank you, Your Honor. Do you want me to draw up little orders?
Yeah, draw a couple orders. It's always best. Not that I won't remember in detail what I said, but it's always good to give orders. You can circulate them to Mr. Judd, okay?
Yes, sir.
Thank you very much. Yeah.
Thank you, Keith.
Okay. Tawana Gale Scott versus Eddie Brandon Scott.
Good afternoon, Your Honor. Alan Dodd for Brandon Scott.
Yes.
Judge, this is our motion, renewed motion for request for sole custody to cease contact and for my client to be allowed to claim both children on this coming tax year because of the lack of payments by Mr. Scott. And currently the visitation back from June of 2021, Mr. Scott's visitation, there was not a set schedule, but his visitation was ordered to be supervised by my client's father at their residence, pending us coming back to court. And then Mr. Scott didn't have any contact with the kids from July until November of this year. And then since November, it's kind of become an ordeal. So that's why we renewed our motion, asking for a hearing for the sole custody and to cease the contact at this moment.
Thank you, Your Honor. And Your Honor, I've been recently retained in the case, but I went through the court's pleadings And the court had originally suspended Mr. Scott's parenting time until he provided proof of a clean hair follicle drug test and an adequate mailing address for service. And then your court entered a June 28, 2021 order stating that he had 10 days to file income disclosures for 2019 and 2020, and that visitation will be temporarily supervised by the petitioner's father. Well, Mr. Scott has filed proof that he's complied with all the court's orders regarding those things. He has filed 4 drug tests, the most recent, a hair follicle drug test on June 14th of 2021. All the drug tests were negative. He's a commercial truck driver. Through his employment, he's drug tested all the time, and all his tests have been negative. He's provided and filed with the court his address on June 23rd of 2021. I provided counsel his updated address. He's filed proof of his income as the court required by filing the tax return, his W-2, and proof of current income. And so there's never been any corroborating evidence to support the allegations of his alleged drug issues. In fact, the evidence that's been filed in compliance with the court's order shows that he has no problems with drugs. And so the concern is, he should be having unsupervised parenting time and go back to the parenting schedule because he's complied with the court's orders or to get to the that was required when the court entered a temporary supervised parenting time order. So, we ask under the law 403-320 that the court would just restore him back to regular parenting time. If counsel wants to move forward on their motion for sole custody, fine setting a hearing date for that. They have to show clear and convincing evidence that he's a serious endangerment to the child because it was filed originally within the 2-year mark of the decree of joint custody. But, right now, there's no schedule setting forth when he can see his kids. So he's just at the mercy of the petitioner and the petitioner's father when he can do that. But he's desperately trying to see his kids. He wants to be an involved father and be part of their lives.
Judge, in response to that,
Speak up just a little bit, please.
I'm sorry.
Speak up a little bit.
In response to that first, he was requested to submit to a hair follicle test in February of 2021. He delayed and stalled in submitting to anything on that until June of 2021, which is well past the 90-day mark that a hair follicle test would pick up. We had a hearing where there was testimony taken in front of the DRC where both his mother and his sister testified that he was a danger to these children. And then he didn't even show up for that hearing, even though his attorney did, so we couldn't complete the hearing. So that's why the case kept getting passed and was passed to June. The income proof that he filed was after we filed motions for show cause. He filed a copy of 1 page of his tax returns for 2019. Then he filed a statement from his current girlfriend as to what she was paying him per month without any proof of pay stubs or a 1099. And that was in contrary to the information he'd reported on his tax returns. You've got those issues. Then we talk about this man, his attorney was filing paperwork in court in June, July, August, and September. Not once did they file a motion trying to come back to establish any type of set visitation.
Who's his attorney then?
Then his attorney was Ken Meredith, who in February, just a week or so ago, filed a motion asking to withdraw from a breakdown of communications with his client. That's been the problem in this case. He doesn't communicate with my client consistently. He's not tried to be involved. He's went multiple times for more than 90 days at a time without trying to initiate contact or have any involvement with his children. He had a fit, called the law, and made a report.
Well, we'll need to take some testimony on this kind of stuff. I want to schedule a full-blown hearing on all the issues that remain here the next rule day as a conclusion of the docket.
Okay.
Which should be about now. Should be about 2:00. Megan, do we have any conflict on that?
You'll have to ask Jessica if we have any confidential matters scheduled.
We don't have any that day. I want the parties to be here in person that day, the attorneys to be here in person, any witnesses to be in person. Unless there's a witness that can't be here, and then you'll just need to notify us to seek permission of the court for them to be taken by Zoom. I want everybody to be fully prepared for a full-blown hearing about the financial matters, and I will include any testimony that's previously been given in the commissioner's hearing. I'll include that in the record. So if you've got anything that you want to bring up, either side does, that contradicts anything that was in the commissioner's testimony, won't be necessary to do that. But some of that is old. Okay, some of that is old. So if you want to call those people again or rely upon their testimony, it'll be up to you. Okay, so it'll be at 2:00 on March the 31st. And I'm not going to enter any temporary orders between now and then because this case has kind of been stalled around a little bit, but I will, if I decide that the visitation has been withheld inappropriately, I will award some makeup time at that time. Okay? Thank you very much.
Thank you, Your Honor.
Yeah, I'm entering the order allowing Mr. Meredith to withdraw here. Okay, thank you very much.
Thank you, Judge.
Thank you, sir. May I be excused?
Absolutely. Okay, Lee Matea Watson versus Barry Shane Roach. When did you serve Mr. Meredith with this?
February the 14th. And Judge, he did not contact me to advise me he had any kind of scheduling conflict or anything until look through my emails. Yeah, it was this week. And it was processed the morning of the 14th and emailed to him in addition to his email or his e-filing notice the morning of the 14th.
What relief, immediate relief?
Well, we're asking immediately that he be ordered to submit to a hair follicle test.
What else?
and that he be required to abide by the terms that we agreed to in mediation.
Well, I need to take some evidence on the second part. Was there a previous order requiring the hair follicle?
That was a part of the agreement in the mediation. I can't remember. Let me go through. I know we've had it.
is an agreed order.
We did the mediation October the 25th.
You
And
have
was
an order with that in it?
Judge, that's been the problem, is we haven't been able to get him to sign an order. And Mr. Meredith is now saying there's no mediation agreement because he just picked up the case from Mr. Brown, who was the attorney at the time of the mediation. And that's kind of been the history in this case. They're trying to throw me under the bus if they didn't get an order.
Well, I don't want to, the thing about it is we can go back to see the tape. He was here and he was called up and asked if he agreed to that. So I'll hold him to that. What you need to do is prepare an order based upon what's in the tape.
Oh, I've got that, and it's already been submitted to Mr. Meredith, Judge.
Well, then you need to submit it to me.
All right, I will do that as well today.
And what I want you to order today and tell him that he has 5 days from 5 working days from today to file any objections to the order as to whether the order complies to the order that was agreed in open court by his client. See if it reflects that or not. And if he doesn't find exception to that, I'll enter the order, that as they agreed to. I don't remember the details, but I remember they agreed. Now, the other thing is I want to order telling him to have a hair follicle test at a reputable lab within 5 days of today, 5 working days from today. And submit the results to you and to the court. And then I'm granting Mr. Meredith a protective order on any other hearings today. We will reschedule it. I want the two of y'all to get back with us. Mutually agreeable day. Within 5 working days of today, the attorneys shall call circuit judge's office for scheduling. If I'm not available, they can do it with my staff lawyer for scheduling on a hearing date for the rest of the stuff. Okay.
And Judge, I'll file a copy of that proposed agreed order here in just a moment with the court.
Okay. Thank y'all very much.
Thank you.
What?
This is the last thing.
Right versus right. See on the right versus right. Respond. Right versus right. Yeah. I saw the results, which I will not repeat for the record. If that's not the problem, if that wasn't the problem, then what should I do concerning your failure to make appearances you required to make? What would you suggest?
I'm sorry, I didn't catch that.
If the problem that we were looking for does not exist, and quite frankly, I'm skeptical about that. But if it does not exist, then what do you suggest that I do about get behind the podium so I can hear you too? What do you suggest that I do about your failure to appear in a timely manner and those sort of things that are there? What would you suggest?
Well, Judge, I don't really have any suggestions. I have, clearly I have some medical issues, some physical issues going on that I'm trying to work through and get past and keep my health to where I can continue to work.
Well, this case right here, I had you down here.
Yes.
Is a bad situation.
It is.
And you weren't here to represent this lady. And
my approach, I could maybe provide the court with a little more information on the situation at hand in that case. Not necessarily to do with the case. It's not about the case.
You you can communicate with us in writing about it. I
I'll
don't
do
want to put
that.
it on the record. But, you know, I'm at a loss as to what was going on with you if it wasn't the other problem that we thought. I don't understand.
Well, Judge, they've diagnosed me with progressively degenerative diseases and autoimmune diseases.
Well, you know,
I'm
I
having,
want you to go into that on the record.
well, that's my issue. That
Okay,
was my
well,
problem
okay,
and
well,
my
give us some
ability.
proof. Give us some proof. And we'll
Sure, Judge, I
do
have
it
it
like
here.
we did. We'll seal it like we did the other stuff. Just write it.
Sure, I
and
have
seal
it. Let me provide it to the clerk. Today, or you want me to mail it?
Just mail it,
Okay.
seal it and mail it. and
Sure.
Mail it to our office. Okay.
I'll do that.
Okay. Now, do you have any other cases pending down here?
No, I don't believe in circuit court.
Well, that's a good thing. So that might be the best way to resolve, because I will not, you know, if we repeat this sort of stuff, it won't be good. So maybe you ought to find someplace else to practice besides this circuit.
I'm hopeful that my health will be
I hope
what
it
we're
is too,
trying.
but maybe it'd be good if you found some other circuit to practice in, because there's such a long history of this sort of stuff that it might be good. Okay, thank you very much.
Thank you.
Okay. That finish everything?